Sithole. Welcome to the members here at M46 and on the virtual. Welcome to the Public Protector and the legal team of the Public Protector, evidence leaders here, the media, our support staff, and everybody from the public on all the virtual platforms. Just to test, because I'm left with one member, and then we're done with this witness. Mr. Sithole, are you there?
Here, Chair. Good morning.
Morning, morning. Mr. Ngola, are you there?
Yes, Chair, I'm here.
Thank you. I now invite Honorable Xola Ngola to interact with the witness.
Thank you very much, Chair. Good morning, members. Good morning, Mr. Sithole.
Morning, Honorable Ngola.
Mr. Sithole, can you tell us how many law firms do you have in your panel of attorneys?
You just need to increase your volume so that we can hear you.
Mr. Sithole, can you hear me?
In the house, your gadget was working very well. Go ahead.
Someone said they look like a pilot. Mr. Sithole, can you tell the committee how many law firms do you have in your panel of attorneys?
Yes, in the previous panel, I think initially there was 26, and then it reduced to about 18 or 19 firms thereabout.
Okay. Can you confirm?
Okay, just before you continue, Mr. Ngola, Mr. Tembigo Sithole, I'll just adjust yourself again. We don't see your head properly.
Chair.
Okay, can you confirm that
you are reminded that you remain under oath?
Thank you, Chair.
Go ahead, Honorable Ngola.
Thank you, Chair. Can you confirm that there is an equitable distribution of work amongst those law firms that formulate that panel?
Yes, I can confirm.
Can you confirm that there is no... Were you saying something?
No, you can continue.
Can you confirm that there is no law firm that has been given work outside the panel that which you formulated as the PPSA?
I can confirm. During my time, I had no knowledge of a law firm that was appointed, which was not in our panel.
Okay. Let's go to the decision of not opposing the applications for review of the reports of the public protector. It is said that at a particular time, the public protector took a decision that it will only file a notice to abide by the decision of the court. Was it done on the basis or on purposes of cost effectiveness or what?
Correct, Honorable Ngola. Cost effectiveness was the main reason.
Okay. You say in your affidavit, paragraph 16, that the public protector instructed Advocate Silius to perhaps look at the relevance of the Gupta leaks in respect of the Fred Dairy project. And Advocate Silius came back and said there is actually no relevance. Now, as a seasoned investigator, the Gupta leaks revealed that there is an about or approximately 84 million rands that was siphoned from the project to an offshore account of the Gupta brothers. Do you really agree that there was no relevance in the Gupta leaks and in the investigation in the Freddy Dairy project?
Thank you, Honorable Ngola. Well, I don't know if Honorable Ngola remembers in my testimony that when I came into the office in May 2017, the Friday investigation was already at the end, even when I was part of the task team. In fact, when it was reported by Ms. Silias that there is no link between the complaint and the Gupta links, I think I was still failing you at that time. And the issue of the Gupta leaks and whether it forms a part of the investigation or has any bearing used to circulate in the email exchanges to say, can we just ensure that there is nothing on the Gupta leaks? And I think eventually there was no finding or an investigation in respect of that.
Okay, in your affidavit in paragraph 14, you depose that the PP raised an unhappiness to the fact that you did not include some of the issues that were raised by Mr. Nemasisi in respect of the Freddy Dairy project. What were those issues that which have made the public protector unhappy?
Thank you, Honorable Ngola. The issues, as I said, I really can't remember the details thereof. And hopefully if the committee maybe will have Mr. Nemasisi can speak on those issues. But I remember our response of Mr. Kekana was that those issues could not have been included as they did not form part of the Section 7.9 notice. But as to exact issues, like this is the issue that was raised by Nemasisi, I can't. I'll be lying if I say I recall the details thereof. Okay.
You don't remember. What stage did you join the investigation into the Freddy Dairy project investigation?
As I said, Honorable Ngola, it was already at the end. So the task team actually was formed to finalize.
Sorry, Mr. Stoller. When you say at the end, you mean towards the actual making, the actual final drafting of the report?
Correct,
Okay.
correct, Honorable.
Do you recall any instruction from the public protector saying she wishes that no politician must actually be affected by adverse findings? Was there any sort of that kind that you recall in the final stages of the Freddy report?
No, that was never communicated to me by the PP.
Okay. The last question, Chair, would be around the issue of the legal costs. Parliament has requested a report from the Public Protector's Office on legal costs in respect of the impeachment process of Parliament and the matters that were taken to review. Are you aware of that?
Yes. Is it previously, Honorable Ngola, or now?
Yeah, just recently. Just recently, I think it's about 4 months or so.
Yeah, I think I would be aware of that if it's 4 months ago.
Are you aware that both matters that were taken to review and the cost on this impeachment process have costed more than 60 million rands of public funds?
Yeah, I am aware of that, Honorable Ngola.
Okay. What is your view in terms of the quantum of the cost in relation to these two aspects.
Thank you. Honorable Ngola, my view is that the quantum is high, not because we are overcharged or anything. The quantum is high because litigation is expensive generally. That's number one. Number two, the quantum is high because taxpayers' money, even if it's R1, it must be, you must rather not spend than spend it on anything. But whether that could have been avoided, I think it's another question, which I will say it could not have been, because then eventually, as previously stated, Honorable Ngola, it led to this process here. And as you will recall, I think there's evidence that was led, which was to the effect that the PP actually wrote a couple of times to the previous speaker to say, you can't start with the impeachment process until there are rules. So the rules did come into place. And then there was litigation in respect of the rules. The litigation was a success for both PP and Parliament, in that PP was part successful and Parliament was part successful, in that some of the rules were upheld, some were set aside. So as to whether it was necessary, I will say it was necessary for the litigation.
Thank you very much, Mr. Stolle. Thank you very much, Chair.
Thank you, Honorable.
Thank you, Honorable Ngola, and thank you, Mr. Stolle. Just three clarities, very quick ones, Mr. Stolle, as we wrap up. You're almost there. I am aware you've indicated that you were in private practice. How long have you been in private practice? Before you joined the PP office?
I only did my articles, Chair, for a period of 2 years.
I missed that you got quiet.
I did my articles for the period of 2 years, and then I went back to PP as investigator.
Oh, okay. So you did articles for 2 years?
Yes, yes.
Okay. Thanks, that helps. Now, how many times in your own knowledge, having been in the PP, how many times has a senior counsel opinion been redrafted by an attorney, discarded, and put under their letterhead?
Very few times, Chair. I think it will be in respect of Ngobeni's opinions.
Nothing beyond that?
Nothing beyond that. Other than that, attorneys always make comments on counsel's opinions before they are finalized, but not to be in the letterhead of the attorney.
Thank you. Thank you. My last clarity, a quick one. Now that you have raised Mr. Ngobeni, has Mr. Paul Ngobeni advised on or provided any input of any nature into any other matter, like your CASAC, your DA, and the Gordon matters?
Chair, my recollection is that he made inputs on this matter. Can you hear me, Chair?
Yeah, just repeat that, your recollection.
Yeah, is that he made inputs in respect of this matter, of the rules and the impeachment process. Chair, I think there's an opinion which I gave to the evidence leaders where he opined about the issue of the rules and whatnot. I can't remember any other involvement, but he's been involved in some of the matters where he provided opinions.
Okay, yeah, I remember. I think the Advocate Bauer did indicate that you'd have received that one opinion yesterday. Thank you for that. At that, I'm going to, in terms of 617 and 6117, ask Advocate Bauer if she has any further questions to engage you on. Advocate Bauer?
Yes, Chair. And maybe up front, I'll say that there are a number of issues that I'm going to raise. I don't generally use this extensively, but today I am, because of the extent to which Mr. Satoli agreed with certain submissions in cross, what he said under direct, and what he answered to the committee, that I am going to be putting a number of questions to Mr. Satoli. And maybe, Mr. Satoli, to start with what the chair just asked you, to clarity, your experience is limited to what you picked up during articles, correct?
Correct.
In private practice. Right.
Correct.
So in effect, when you commenced back at the PP's office, you had less than 3 years management, sorry, let me rephrase that. When you were appointed as the manager legal services, you actually had less than 3 years management experience, correct?
Correct.
Right. Now, all CNAGO's bills get paid through legal services, correct?
Correct.
And they get sent directly to you. You as the end user department sign off of them, and you then forward them on up the chain for payment. Would that be correct?
Correct. Correct.
And would it be fair to say that the bulk of the bills submitted by CNAGO since they commenced services in 2018 was signed off by yourself?
Correct.
Right. You were then asked whether you regarded the expenditure of legal services to be wasteful and fruitful expenditure. And you indicated no. But in effect, if you admitted that they were fruitless and wasteful expenditure, you'd have then had to admit that you approved fruitless and wasteful expenditure. Wouldn't that be so?
I don't get that. SC
Mr.
can.
Mpofu put to you the proper.
Chairperson, before she puts it to him.
I did not see your hand.
Oh,
Advocate
I
Mpofu.
apologize, Chair. This computer is failing me today. I can't find the place with the hand.
Okay, and you must try and adjust. It
Oh,
looks
there,
like you are hiding where you are.
Okay, sorry, Chair. Okay.
Just pause, Advocate Bauer. Advocate Mpofu.
Okay, thanks. I've found the hand as well. Yeah. Chair, can you hear me?
Yes, we can hear you.
Okay, I can't see you. I can't see anybody, but if you can hear me, I'll just continue talking. Hold on, please, Chair.
You said my gadgets are pathetic. Yeah. You're getting one.
I'm getting my revenge. You're getting your revenge, Honorable Paul. Okay, I'm back, I think, yeah. Thank you. So sorry, Chairperson, I didn't mean to interrupt, but I just want to know what's happening now. Because it looks like Advocate Bowers is cross-examining her own witness, yeah, and putting it to him and all sorts of things. Firstly, she can't do that. But secondly, if she's going to lead anything new, which is not in the statements, then she'll have to let us know and give us the normal notice, and then we can deal with it and cross-examine on that new material. Otherwise, she should have covered it in chief. I mean, this just underscores the unfairness of even this situation where they are the only ones who are given the second bite at the chair. But even that second bite is meant to be for clarification, as you said, Chair, not for cross-examination or anything new. So I'm objecting very strongly to whatever she's trying to do now.
Thank you, Advocate Mpofu. You've asked what is happening now. She's, as you indicated later on, she's on the platform in terms of 616 and 617.
I know
I
that.
am aware of your issues with that. And so far, I have not picked anything new she's raising, and I'm going to ask her to respond.
Mr. Chairperson, there are things that Mr. Mpofu raised under cross-examination that were new. And I'm entitled to obtain clarification in respect of those issues that were raised. And I'm entitled to obtain clarification in respect of questions and answers that were given to the members in relation to answers that were given to me under direct examination. I don't intend going beyond seeking that kind of clarification, save in one respect, and that was the opinions that Mr. Satauli had provided as an indication of what had been given by Advocate or Mr. Nkubeni, which I had provided to Mr. Mpofu, and I may not even go to the opinions directly, depending on what Mr. Satauli's answers are. So there is no cross-examination. If I'm endeavoring to get clarification as to what he's saying, then I want to get through this as quickly as possible so that we can get on with the day without interruption, if I can be permitted to do that.
Okay. No, thank you, Advocate
Chairperson, sorry.
Yes, Advocate Mpofu.
Yeah, no, I think it's ridiculous. I don't know what interruption is Advocate Bao talking about. I'm making an objection here, and I'm raising a point, and I've outlined it, and she has answered it. What interruption is she referring to?
I'm not saying there has been an interruption. I'm saying that as I proceed in the day,
okay, no, that's fine. No, thank you. Thank you. No, okay, Chair, then whatever your ruling is going to be, at the very least, if she's going to raise anything new in relation to the opinion or whatever, then I will exercise my right to cross-examine on that new material. Thank you.
Thank you, Advocate Mpofu. I hand over to Advocate Power.
Mr. Satauli, you were asked by Mr. Mpofu, Advocate Mpofu, whether you regarded the expenditure of legal services to be wasteful and fruitless expenditure, and you indicated no. In fact, you further indicated that you never experienced wasteful legal expenditure. Did I understand your answer correctly?
I remember saying no.
Right. And I'm putting to you, you the end user that sign off on these invoices. And effectively, if your answer had been yes, you'd have been one of the parties responsible for such wasteful and fruitless expenditure, correct?
Correct.
Now, you also offered in cross-examination the view that when it came to dealing with litigation matters, that context is everything. Did I understand you correctly when you said
Correct.
that?
Correct.
Right, I'm going to come to that in a moment, but let's go to Mr. Nkubeni. And let's just see if I understand your evidence correctly. You don't have personal knowledge as to whether or not he's an advocate.
Correct.
You don't know, for that matter. In fact, you can say you don't know whether he's a practicing advocate.
Correct.
You can confirm that he's not a member of the bar.
Correct.
You can confirm that he's not an SC.
Correct.
Now, this may have been a slip of a tongue, but you said that you were aware that he practiced as an advocate in the USA. But it might just be, you're aware that there's no system of advocates and attorneys in the USA.
Yeah, I think I even said I was told by the chief of staff that he practiced in the USA as an advocate.
Yeah. Sorry, Mr. Satauli, I'm just battling to hear that.
You just faded. Just repeat that part.
Can we? Oh, I said I remember being told by the late chief of staff that he practiced as an advocate in the United States.
Right. What else do you
that?
know about it? Yes, we did. Thank you, Mr. Satauli. What else do you know about his US experience?
Nothing.
You were not told anything else by the chief of staff.
Correct.
Now, it was put to you by Advocate Mpofu that this thing was directed at a particular brief, and your response was, I'm aware. I couldn't quite understand what thing he was referring to, but in the context of this, was it can you clarify that?
No, I can't remember what this thing was, unless Advocate Mpofu maybe clarifies that.
Now, your evidence was, you confirm that Mr. Nkubeni was engaged on the recommendation of the late Mr. Nyembi.
Correct.
How did you know this?
Because we used to actually get instruction from Mr. Nyembi on the appointment of Mr. Nkubeni and other counsel.
Now, that doesn't answer the question. How did you know that it was Mr. Nyembi that recommended Mr. Nkubeni to the PP?
He will send emails, he will call, he will pop into the office. There's many instances where he will communicate how we appoint counsel and who we appoint.
See, I want to be clear that it's not left to speculation as to how Mr. Nkubeni came to be appointed, right? Now, you were told that Mr. Nyembi was a great admirer of Mr. Nkubeni and you agreed. What did you base that on?
From what he used to say about Mr. Advocate Nkubeni, used to speak a lot about him.
What did he say?
That he's a brilliant thinker, he has good legal acumen and all that. But there's many things he used to say about Advocate Nkubeni.
Can you tell us what else he used to say besides that?
Nothing else other than the good things that he said about him.
Right. Now, you agreed with Advocate Mpofu that Mr. Nyembi's mandate was wider as a wider in what sense?
That he was the chief of staff and he also used to oversee legal services. I think even during the time of Nemasisi and Mr. Mhlongo, he still used to oversee legal services.
What do you mean by oversee? Because in the reporting line, the legal services does not answer to the chief of staff.
He used to be involved in most decisions making relating to litigation.
Did you have to follow Mr. Nyembi's instructions?
Yes, whenever he issued them, because I will believe that he must have consulted with the PP.
Right. Now, you were asked by one of the members as to whether any consideration was given to the appropriateness of the person being briefed. And your answer was that the instruction, I understood that to mean the instruction to you, correct?
Yes.
That instruction would come to you after the issue of appropriateness had been given thought to. Was that your evidence?
Correct.
Now, if that instruction ultimately came from the PP, is it your evidence that she would have had to give thought to the appropriateness of the person being appointed?
Yes, she would have known the person, that is, whether the person is good in that area of the law or whether the person can render an appropriate opinion or whatever reason she believes that warrants the person to be appointed.
Right. Now, you also agreed with Mr. Advocate Mpofu that there was a hostile political, economic, social environment and that Mr. Nkubeni was recommended to supposedly navigate this hostile landscape with reference to a political, social, economic milieu.
No, no. Sorry, Chair. Chair.
Just a pause, Advocate Bauer. I see that your hand comes after you have intervened. It doesn't work like that. Advocate.
Apologies, Chair. Yeah, no, that's not true. I never said what is being attributed to me now.
You dispute that?
Well, not, I don't, it's never happened. It's not.
Okay. Okay. Thank you, Advocate Mpo. Advocate Bauer.
Mr. Sitauli, do you recall answering Advocate Mpofu's questions in respect of a hostile environment within which the PP operated?
Yes, but I think that must have been contextual on the issue of how Ngobeni was appointed, if I remember correctly.
Sorry, Mr. Sitauli, you're fading again. I didn't get that.
I think that was based on a certain context which he had put into place.
No, actually, it was a general question, but maybe you can tell us what context you understood the question to be in.
No, I'm saying maybe it was put in a context, so I can't remember what the context might have been.
Yeah, I wanted Mr. Sithole to complete his answer hand, but I'm going to hear what you have to say. Are you done, Mr. Sithole, to answer that question?
Yes, Chair. Chair, maybe let me request that questions that are put to me must relate to the answers that I've given and not what someone else said. Otherwise, I might misrepresent what someone else said.
Oh, okay. Advocate Mpofu.
Thank you, Chair. No, mine is very short. Now, I wanted to assist so that we don't waste time. Yeah. The question that I think Advocate Bauer is looking for is when I put to Mr. Sithole that the Public Protector's Office operates in a generally hostile environment. And I think I even said that has nothing to do with Advocate Mkhwebane per se. It applies to every public protector. That's yes. The question I think she's looking for.
Yes.
Thank you.
Okay.
That was the question. Thank you, Chair. And the context and everything, so that they don't search for context or the wording of the question when I'm sitting here. I'm the one who asked the question. I can assist you.
Okay. Thank you, Advocate Mpofu.
So,
Advocate Bauer.
Well, let me put it to Mr. Sitauli. It was a threefold question and a threefold answer. The first proposition was Niembi's mandate in the PPSA as special advisor was beyond legal matters. Also communications, political landscape, economic landscape, and an operating environment. And your answer, Mr. Sitauli, was yes, when he was special advisor and chief of staff. You recall that?
Correct.
Mr. Mpofu, Advocate Mpofu then put to you the hostile environment in which the PP operates by nature of the office. You agreed that there was a hostile environment in which the PP operates by nature of the office.
Correct.
Right. I'm asking you, what is that hostile environment to which you agreed the PP operated in by nature of the office?
The hostile environment is simply in the mandate of the PP, that the PP actually has the mandate to investigate all corners of administration. So there is not always going to be every member of the executive particularly who is happy that he or she is being investigated by the PP. And in my time when I was here at PPSA, some members will go out in the public to attack the PP. Some will attack during the matters that she was investigating. So for me, by hostile environment, I mean the environment in which people are not happy that the PP is investigating them. And that is not a political statement. It's a statement that was mentioned by Mogoeng in the Nkandla judgment, if I'm not mistaken, that by the nature of her position, she is most certainly likely not going to be liked by anyone who is being investigated by her. So that is the hostile environment I understood Advocate Mpofu to be referring to, which I can confirm that I'm aware of it. It's common cause for me.
Right. So following on your response to that answer, it was put to you that the evidence will be that Niembi was of the view that because of this hostility, someone who is not a straitjacket lawyer and won't just deal with legal issues, someone like Ngubeni was appointed. And you said you cannot dispute that.
Correct.
Right. So effectively, someone like Ngubeni was appointed to deal with matters beyond legal issues.
I will say correct. I don't think Advocate Bauer, that's the correct context in which Mr. Nyembe referred to the issue of political and legal. I think he meant you want someone who has the knowledge of politics and the law, not that you want both the political service and the legal service. I think that's the context in which he referred to. But unfortunately, he's not here to answer for himself. I now have to second guess what he exactly meant.
Now, you see, Mr. Satari, it's not second guessing. You agreed with the statement. And so I'm trying to explore what was your understanding in agreeing with the statement to do that. I'm not suggesting you need to second guess the late Mr. Niembi. It's your agreement that I'm exploring.
Yes, and I think I provided an answer, SC, unless it was not clear enough.
You also agreed with Advocate Mpofu that Mr. Ngubeni's engagement was based on his legal expertise, which you obtained from Mr. Niembi, and his standing as a writer in the public space. Now, there's two questions arising from that I want clarity on. You've already answered partially on this question of legal expertise. You have a law degree, a South African law degree, correct?
Correct.
Do you know whether Mr. Ngubeni has a South African law degree?
No.
So the only legal expertise that you're aware of is what Mr. Niembi relayed to you. Would that be so?
Correct. Correct.
In fact, if one has a scrutiny of Mr. Ngubeni's invoices to Cianego, they don't even comply with the tax laws in this country, but that's another point. Are you suggesting that as an advocate, standing as a writer in the public space would have a bearing on his expertise to render legal services? I wasn't sure how you answered the second part of that. That's why I'm asking you.
I spoke on the legal expertise, SC, that I can confirm on the basis of the opinions that he has rendered, the first which he rendered when Mr. Nemasisi was here, and others which he rendered subsequently there too. I think those are opinions that if one reads will believe that this person is a legal expertise of some sort.
So your agreement with Advocate Mpofu had nothing to do with his standing as a writer in the public space?
No, I wouldn't know his standing as a writer in the public space, and I don't think I have agreed that he has a good standing or bad standing as a writer in the public space.
Just so that we not at cross purposes. It was
Just before you proceed, I see your hand, Advocate Mpofu.
He's muted, Chair.
No, thanks, Chair. I'm sorry, my computer skills this morning are not up to scratch. Sorry, I should have taken that hand down. Sorry.
Okay, thank you. Advocate Bauer.
You see, Mr. Satoli, I seek this clarity because it was put to you that one of the reasons for recommending Mr. Ngubeni is because he would bring legal expertise and standing as a writer in the public space. And your answer was yes.
Yes, and I said the context was why Mr. Nyembe would have believed in Mr. Ngubeni.
Sorry, Mr. Satoli.
Can you
Your
hear me?
answer was just a yes when you said it under cross. Are you elaborating on this now?
No, I mean, the context was in reference to why Mr. Nyembe would have recommended Advocate Ngobeni. And they stated both the writer in the legal space and I mean, public space and law.
So would you agree that whatever standing you may or may not have as a writer in the public space has no bearing on your expertise as a your expertise to render legal advice?
Come again, Essie?
Would you agree that whatever your standing may be as a writer in the public space, it has no bearing on your expertise to render legal advice?
Correct.
You also agreed with Advocate Mpopo that some of his work was legal input and other times it was communication input. Now, what other of his work identified as communication input were you referring to?
I think that was in the context of the invoices that were flighted. I think in relation to the two articles that were mentioned there.
Right. So I put something to you under direct, right? And I asked you, are you aware of any involvement on the part of Mr. Ngobeni other than what was put on the screen, being invoices, the GRN forms about Mr. Mboweni's opinion, the traveling, the meetings, the research, the reading, the drafting of the PPSA's response and letter to the National Assembly, and the submissions to Portfolio Committee, the opinion on the President's investigation, the advice on that strategy, effectively everything that was in the documents which was flighted, including the articles. And your response to me was that as far as you were aware, Mr. Ngobeni had only been engaged to provide the opinions the PPSA had paid for. You didn't specify the opinions, but later on you said in respect of at least 2 or 3 matters. Do you recall that?
Yes. Yes, SC.
Right. So we must add to that, in addition to the legal opinions, he provided communication input in respect of the articles and got paid for them as per the invoice.
I'm not sure if I get that part.
Okay, so let's break this down. He renders legal advice in the form of legal opinions, correct?
Correct.
He did that on your version 2 or 3 times. I think 3. Let's fix on 3 because you've provided me with 3 instances on which he gave advice.
Yeah.
Right. I'm going to come to those 3 instances in a moment. Right. You're not aware of any other services rendered by Mr. Ngobeni apart from those 3 opinions and the 2 articles that are flighted on that invoice. Is that your evidence?
To which he was paid?
For which he was paid?
No, not to which he was paid. I know that he also assisted. I think I also related that to the chair's last question in some matters, including the one of the rules. I know he made inputs in respect of how that litigation should go about up to the stage when we engage the services of Advocate Mpofu.
In which matter are you now referring to?
The impeachment matter.
And in any other matters?
To my recollection, no, I can't remember now out of my head.
Sorry, Mr. Satali, we've lost you again.
He says he can't remember any other.
I can't
You-
recall out of my head. SC.
Right. I'm going to come back to that opinions in a moment, but let me just deal with it in this way, right? Advocate Mpofo put to you, I think what he said, 7 different ways in which an external legal advisor can be briefed. Do you recall that?
Correct.
And as I understood your evidence, it was that the appointment of Mr. Ngumbeni was from the inception of his appointment on the recommendation of Mr. Nyembi. Is that correct?
Correct. That's correct.
You see, now, as I understood your evidence to be, Mr. Sitauli, you started at Legal Services in April 2018, correct?
Correct.
Mr. Nyembi started as a special advisor in April 2018.
Correct.
So if Mr. Ngubeni was briefed on the recommendation of Mr. Nyembi, then that would have been subsequent to April 2018. Would that be so?
That should be correct.
And if he was briefed prior to April 2018, what then?
That would have been from the PP.
What do you mean that would have been for the PP?
I mean, the instruction, that will be before my time. So I can't say for sure that that instruction might have come from the PP.
But it certainly couldn't have come from Mr. Nyembi because he wasn't employed as a special advisor. Would you agree with that?
In 2018,
Yes.
I can't remember when Mr. Nyembe was appointed as Chief of Staff. Because he was special advisor and then he was appointed as Chief of Staff.
Let me help you, Mr. Satauli, because I confirmed this with Mr. Chelele yesterday. He was appointed as a special advisor during the period from April to July 2018. He was then not in the employ of the PPS until January 2019, when he was employed as a Chief of Staff.
Yes.
Correct? Would you
Correct.
accept that?
I will
for the
accept
moment?
that. Yes.
Right. Now, if we look at the invoices rendered, and to be exact, Mr. Nyembi started on the 10th of April. If you look at the first invoice rendered by Mr. Ngubeni, which you find as part of the bundle 125, page 1826, the first date on which he renders a service is on the 31st of March 20. No, sorry. Let me go back. Now, my apologies, Mr. Satauli, the proposition is wrong. He rendered the service, the first service he renders on the invoices is on the 28th of June, 2018. So that falls within the period of which Mr. Nyembi was engaged. My apologies. Right. Are you aware of any direct instructions given by the PP to engage the services of Mr. Ngubeni?
Not to my recollection.
Right. So let's just deal with the 3 opinions that you say was provided by Mr. Ngubeni. The first one we discussed under direct examination. That is the one which was rendered on the 11th of April 2019 under the Cianago letterhead, right? And the second one.
Is the first
Was
one
it-
not 2018 SC?
I'm not giving them in date order.
Oh, okay.
Yeah, I'll come to the second one, is the one you provided more recently. That is the one that was rendered on the 25th of July, 2018, when Mr. Motsitsi was in office,
Correct.
right? That was in July 2018, also styled as an advice from the attorney. Correct?
Correct.
And the third one is the one related to Mr. Mboweni, which is undated, but if you look at the fee note, it's rendered in February 2019, based on what he says. Now, none of these are signed by Mr. Ngubeni.
Correct.
It's not styled as a legal document in respect of which legal privilege could be claimed. Correct?
Correct.
It doesn't refer to any instruction, and it doesn't make reference to any brief being provided. Agreed?
Correct. Correct.
You haven't provided any memoranda with an instruction to CNAGO to brief Advocate Ngubeni directly. Did you generate a memorandum to that effect?
I'm not sure if I get the memo. Which memo, SC?
So let me give you an example. You provide the attorney with a memorandum when you seek legal opinions in relation to the nature of the legal opinion being sought. Do you not?
It's a letter, SC usually.
Not always.
So
a
in
letter.
in the letter we'll put what opinion we want.
In the Pusasa matter,
Yeah.
you provided a memorandum to CNAGO with an instruction that the senior counsel must be briefed to provide the legal advice. Did you not?
I think that's a letter, SC, if I'm not mistaken. We don't do a memo to an attorney. We send a letter to appoint them and the basis upon which we appoint them.
Okay, let's call it a letter.
Yes.
You provided a letter which reflected the instructions in relation to which you sought to approve and to provide the services of the senior counsel.
Correct.
In fact, the invoice to which we referred specifically says that they are to brief a senior counsel, that they are assisting in the brief of a senior counsel, correct?
Correct.
And yet you didn't get an opinion from a senior counsel.
Correct.
And why was that? Why was that not taken up with the attorneys?
Obviously, the attorneys will check with us on the issue of counsel. So if we specify the one senior counsel, they will check which senior counsel, unless we have told them which senior counsel, or subsequently to the sending of the letter, the instruction might be broadened or narrowed, and the name or status of the counsel can be changed also, maybe to from senior to junior. So there is such instances when the letter will say brief senior counsel and then the attorney will brief a junior. Or we see where we say brief a counsel, not specify if it's a senior, a junior, or junior, and then the attorney will give us a call or email. Then we say no, in fact, brief a senior counsel.
Right. Now you gave me a general response. Was that what occurred in respect of this matter? Did the PP accede and give you an instruction that instead of a senior counsel being briefed, that Mr. Ngubeni can render this advice?
That would have been the case.
Now, was Mr. Ngubeni paid directly or indirectly for any other articles or legal advices beyond the 3 to which you referred?
I know he was paid from the attorney in respect of the advices that he rendered.
Now, Advocate Mpofu put to you, and you agreed that Mr. Ngubeni's services were acquired through whatever attorneys were involved in a particular matter, quote unquote. And you agreed with that statement. But in answering the question from one of the members, you stated that he was only engaged through the services of Cienego. Now, was he only engaged through the services of Cienego, or was he engaged through the services of other attorneys as well?
I only know him being engaged through the services of Cienego. Don't think there's any other attorney who has briefed Advocate Ngobeni through us, unless it's something I don't know about.
It was put to you that except for the situation where Mr. Ngubeni was briefed with an advocate, you would not have been privy to what other services he would have been briefed for.
I'm not sure
Quote
if I get that.
Well, that was what was put to you. It was put to you that except for the situation where Mr. Ngubeni was briefed with an advocate, you would not have been privy to what other services he would have been briefed for. And you responded that your involvement related to obtaining only the opinion.
Chair.
Yes, just pause, Advocate Bao. Advocate Mpofu.
No, Chair, okay, that's not true. What I put to the witness in relation to this, if it's the same question, was if Advocate Ngobeni was briefed for given a particular mandate, he, meaning the legal department or the PP's office, would not be privy to what other services that advocate would acquire in the pursuance of that brief. And I think, again, I made an example using myself. And I said, if I needed a specialist in this or that area, I can't remember now the question verbatim, but that was the question, not what is being misquoted now.
Okay, Fred Bao. Thank you.
I accept Advocate Mpofu's explanation. My note says that except for the situation where Ngubeni was briefed with an advocate, he would not have been privy to what other services he would be briefed for. But let's not have a fight, Advocate Mpofu. I'll accept your version and I'll rephrase the question to Mr. Sitauli. Hi, Mr. Sitauli. If I understand your answer, you said that your involvement in respect of work rendered by Mr. Ngubeni was restricted to that in respect of which he provided these 3 or 2 opinions, the one preceded your involvement. Did I understand you correctly in that regard?
Yes, in respect of matters in which he was paid by our office through Cienego.
Are you aware of any other consultant or service provider that had been paid by Cienego for services rendered to the PP?
No, as in we pay Cienego and Cienego paid a consultant.
I was asking a question.
Now, Mr. Sitauli, are you now saying you are aware of situations where Mr. Cienego?
Just pause. Please mute Advocate Mpofu.
Oh, sorry, Chair.
Thank you. Advocate Bauer.
Are you now saying that there were consultants employed that Cienego paid? Or are you saying you're not aware of any consultants that Cienego paid?
No, I'm trying to understand the question of the chain of payment, as in we brief Cienego to brief a consultant or advocate we pay Sianejo and then Sianejo pay those consultants. That's the clarity I'm trying to find.
Right now, which consultants would be paid by CNAGO apart from advocates?
That's what I'm trying to understand. If that is the question, is that the question?
Yes. Are they
Apart
let's
from
take a
CNAGO?
step back. Presumably, when CNAGO engages the services of consultants for purposes of rendering services to the PP, it's done with your knowledge.
Correct.
Did CNAGO engage consultants to render services to the PP's office with your knowledge?
No, not as far as I remember in terms of services that the office paid for.
Right. Now, Advocate Nthoriseng put to you that there is another example where it was more communications input than legal input. So legal services refused to pay. Do you recall that? And your
Yes,
response was, right. And your response was, I'm not sure, but I think I can recall there was such a case. Right. And I want to put a statement on the screen, which is at bundle F, page 2997. Item 145, Mr. Mpofu was reluctant to put a document referring to an attorney on the screen. I don't share that reluctance, and I want to check whether the example being referred to is what you and Advocate Mpofu was referring to. If you look at the line item at 2997, which says media publications, is that what you had in mind, Mr.
Yes.
Sitauli?
Yes, I think that's
Is
correct.
that what you understood Advocate Mpofu to be putting to you?
I think that's correct, yeah.
All right. That is a line item that is dated. It's the top one in yellow that I'm referring to, dated the 25th of August, 2019, and it's media publications. Just for the record purposes, this is a statement that is issued by CNAGO at the end of a month to the PP's office, correct?
Correct.
Now, explain to us the context of that line item, Mr. Sitauli.
It says media publication SC. I'm not sure if I'm missing something from the statement.
It has an invoice number reference to it. This is a statement which refers to invoices rendered, correct?
Correct.
And it reflects an amount of 416,726 Rand and 40 cents as being what is raised on this invoice.
Correct.
Just a pause. Advocate Mpofu, you have your hand up?
Yes, Chair. No, just a quick one, Chair. I just wanted, in case I don't think Advocate Bauer is misrepresenting what I said deliberately. Maybe it was vague. Just for the record, that I've never seen this document. So if I was referring to something, it was not this. So this will be one of the new things in respect of which I will seek to ask questions in cross-examination. Thank you.
Advocate Mpofu, you put to him, there is another example where it was more communications input than legal input. So legal services refused to pay. Are you saying that that was not what you put to him?
No, you must listen to what I've said. I never said you put that to him. I didn't say anything. It's only when you put this thing up here, I'm telling you that if whatever it is, I've never seen this. I'm seeing it for the first time. And I'm only saying it in relation to my right to cross-examine. I'm not saying you mustn't ask questions.
I was actually alerted to it by your junior, but we'll leave that.
Yeah, well, so what are you saying? Am I lying? I say I've never seen this.
No, I'm not.
Are you saying I've seen it? I don't care who I accept you. I'm telling you that I have never seen it myself. It might be in the bundles, it might be everywhere. I'm just saying I have never seen it. I don't know what the problem is with that. So I'm saying whatever question I was putting, I was not basing it on this particular document because I have never seen it. I mean, what's difficult to that?
I'm asking the witness whether his response was based on that particular invoice.
Anyway, Chair, I've placed what I've placed on the record.
Yeah, thank you, Advocate
Deal with
Mbofu.
it in cross-examination. Thank you.
Mr. Satauli, you've confirmed that was the invoice that you had in mind when you answered Mr. Mpofu. We can take it off the screen.
Okay.
Is that correct?
Not the invoice per se, but instances where there's a communication side than legal. I don't think it was specific to that invoice. But in any event, I'm happy to go through that SC. You can put it up there.
All right, well, let's take a preceding question. Has there been more than one invoice that there has been a refusal to pay on the basis that it is a communications matter, not a legal matter?
No, I don't remember if there's more than one.
So is this the only one that you're aware of?
I think that's the only one I'm aware of that relates to media publication. But in respect of other legal matters, there are some invoices which we refuse to pay.
And for reasons other than communication content?
Correct.
All right. Can we just scroll up 2 pages?
Just as you do that, can you just confirm that because Advocate Mbofu says he's never seen that document?
It was put, in fact, Chair, it came up in the context where we had a pre-trial meeting amongst ourselves where objections were, where there was a discomfort raised, not unfairly, maybe just scroll down to the handwritten part by the legal representatives, which I appreciated, about fee invoices being put into the public domain. And Advocate Mpofu Jr. Raised an objection that it appeared that only Cienego or their invoices were highlighted. There is a bundle of invoices which is not in the public domain, which I had disclosed to the other side. I then went back to go and look at what's this highlighting that's been referred to. And I came across this document, which was then separately put onto bundle F 2 days ago when it was there. So it was made available on the 7th of September onto the bundle. I don't, for a moment, if Advocate Mpofu didn't look at it, I accept he didn't look at it. But this is how we...
So this was shared?
Shared on the 7th.
Okay.
Right.
Chair.
Yes, Advocate Mpofu.
I'm sorry, Chair. You know, I don't know what's so complicated about what I've just said. I've said 2 things, Chairperson. I've said one, Advocate Bauer even said now, I'm not saying the thing is not in the word of bundles, but I can't claim, anyone cannot claim to have read everything that's on the bundles. I'm saying that this document was not, at least 1, I've not seen it. 2, it has not been raised by Advocate Bauer. If she says she put it up 2 days ago, then she should have raised it when she was leading the evidence of the witness yesterday morning. To the extent that she did not do so, I've said that I will deal with it with my when I exercise my right to cross-examine, which I have, because I can't be, there can't be new evidence that's brought under this so-called rule, whatever it is. And then the effect of that is to deprive me of my chance to cross-examine on the witness. So that's the only thing I'm saying. Otherwise, I'm not stopping the questions.
Advocate Bauer, please continue.
I am going to continue, but let me also place on the record that it comes out directly as a context of a question that Advocate Mpofu raised on the cross. And because of the generality of the question, my only referral to the document is to place a context to the example in which it was alleged there was a refusal to pay. I don't need to refer to the document to ask that, but one needed to show Mr. Sithole, and I wanted the context of precisely what he was recalling as having been the case. But be that as it may, Mr. Sithole, if we scroll up on that document, these invoices were paused by instruction of the CEO due to queries, correct?
Correct.
Right. It wasn't stopped by legal services, it was stopped by the CEO.
I don't know what due to queries. I don't know is it the CEO's query or is it our query?
It says, just scroll up, Shepo. It says invoices were paused by instruction of the CEO during queries. Just go right to the top. This is a statement recon issued by your officers in the request of payments due to Cianego. You see that?
Correct.
And under the first line item, less invoices on statement not received, you see 41672640.
Correct.
Right. Did you ever receive this invoice that was attached in respect of that line item?
Can I see it? Is it here on this bundle?
It's not on this bundle because I haven't discovered this invoice. I'm asking you whether you received the invoice to which that line item refers.
If it's reflected by finance, then we must have received that invoice, yes.
Sorry, Mr. Sithole, you faded again.
If it's on a finance document, then it means we must have received it because they send invoices to finance.
Right. Now, to your recollection, did that invoice relate to services rendered by Mr. Ngubeni?
I can't remember. I would really want to see the invoice. Yes.
You see, Mr. Sithole, you remember lots of stuff, but you don't remember services rendered by Mr. Ngubeni in other contexts.
I do, but I want to speak on what I see.
Chairperson.
Yes, Advocate Mpofu.
No, this is now bordering on the ridiculous. I made an objection a long time ago. This is now full-blown cross-examination about his memory and credibility and all that. And I don't know if you, Chairperson, she can't cross-examine her own witness. She knows that. So, and that's why she denied it. But that's exactly what she's been doing for the past hour. You know, if she wants to declare him a hostile witness, she must do so and then cross-examine him. But we can't have this kind of joke now.
Oh, Mr. Chair, through you, I'm an evidence leader. I bring witnesses to provide information to the inquiry. They're not my witnesses. They're witnesses that come here. If they do not make full disclosure to this committee, and I question the disclosure that's made, then I should be questioning these witnesses on the lack of full disclosure that's being made. It's not a question of cross-examination. It's a question of making sure that the full information is placed before this committee.
Thank you.
I don't own any of the witnesses that come here. I don't act for them and I don't represent them.
Okay, thank you. How far are you from wrapping up, Advocate
So
Bauer?
I'm going to need a bit more time because the witness isn't providing me with the answers. And I
Chairperson.
keep on,
Really, man.
Yeah, that's not helping me now, the chair.
My
Advocate
hand
Mpofu, I want us to proceed.
Yes, no, Chair, sorry, I promise you I won't waste your time. No, my hand was up. No, I'm saying Advocate Bauer can do whatever she wants to do for as many days or weeks as she wants to. All I'm saying is that she must not cross-examine her own witness. If she wants to lay a basis that the witness has not put a full disclosure or whatever she's saying, then she must do so. And on that basis, you can either allow her to ask certain questions or not. But she's not done what she's doing. She knows it. You know, and this guys to say it's not her witness. Who took the statement and prepared the witness? It's her. So we can't now disown the witness when it suits her. I know that she's an evidence leader, but
Okay.
these are witnesses that are called by the evidence leaders. There's such a thing in the directive as witnesses called by evidence leaders and witnesses called by the public protector. And there's a difference between how they should lead evidence, who should lead their evidence, who should ask them questions, who should cross-examine them. It's all in your directive, Chairperson. You can't just allow a jamboree, which is you know, indescribable and never seen before to happen. There must be structure to what is happening. That's why my first question in the morning was, what is happening? Is
Thank you.
Cross-examination? Is it declaration of hostility? Is it what? We want to know what it is so that we can deal with it. Thank you, sorry, Chairperson. Sorry about that.
Yeah, thank you, Advocate Mpofu. I'm going to allow Advocate Bauer to continue. She did explain, and I explained to you what we've started doing this morning.
Okay, just explain it to me again then, Chairperson. I don't know what is happening.
with respect, really.
Please, Advocate Mpofu.
No, Chair, I'm being serious. You say you explained it to me, so I'm begging you to explain it again. Because I still don't understand it.
Started, she is asking questions,
Right.
and the directives allow her to do that. How you describe that as cross-examination and so on, it's how you understand it.
How do you understand it? How do you understand it?
I understand it as part of 616 and 617 from the directives. Thank you, Advocate Mpofu. Continue, Advocate Bauer.
Well, for the record, that's not what it is, Chair, but I won't press the point further. I've made my point. Thank you.
Okay, thank you. Advocate Bauer.
Now on page 2990 of the same bundle, there's an invoice rendered by Sienega on the 20th of December 2019. And I want to take you to the next page, the first line item in that page. On the 13th, right on top, it says, emailed Mr. Ngubeni regarding the interlocutory application. You signed off on this invoice, Mr. Satauli, did you?
Correct.
What involvement did Mr. Ngubeni have in the interlocutory application relating to the Minister Lordlaw?
I'm not sure, as far as I know, I'm not sure if this is the same one that was dealt with by Advocate Skakane.
It just go up. It's the first line item says it's Advocate Masuku on brief.
Okay. Oh yeah. Okay. Yeah.
And my question is, what involvement did Mr. Ngubeni have in respect of this matter? Why would the attorneys be communicating with him?
I'm not sure. I really am not sure.
Just go down again. Do you scrutinize the invoices before you pay or you authorize payment?
Yes, we do.
It's a nominal amount. You didn't seek to query with the attorneys why they're consulting with Mr. Ngubeni in respect of or sending emails to Mr. Ngubeni regarding the interlocutory application?
Yeah, it means it was not queried. SC.
Sorry, Mr. Sadali, I didn't get that.
It means it was not queried.
Now, in respect of the Vrede matter, you already indicated that you were integrally involved. And one of the members put a question to you that the law firm, which I'm going to abbreviate as TGR, handled the matter. And they were then substituted when it came to the appeal process
Correct.
with CNEGO attorneys.
Correct.
Right? And your evidence was that you can't remember why CNEGO was replaced in the appeal process. Is that your evidence?
Why TGR was replaced? Yeah, I can't recall it.
Now, let me see if I can assist you. Mr. Ngobeni is paid through the attorney CNEGO. Did Mr. Ngobeni get any instruction to have any involvement in the Vrede matter?
I'm not sure. SC, at which stage? At the appeal stage?
At the appeal stage, after the Talmay judgment was handed down, did Mr. Ngobeni have any involvement in the Vrede matter subsequent to that? Your evidence was that you were integrally involved in this matter.
Yes.
So, Mr. Satali, I'm asking you again. Was there any instructions given to Mr. Ngobeni to get involved in the Vrede matter subsequent to the judgment being handed down by Judge Talmay?
My recollection is that we had advocate Botes to file the appeal and to argue leave to appeal. And from when leave was refused, when we filed the direct access to the SCA, I think those papers were filed by Advocate Sikakane, if I recall correctly.
Mr. Sitauli, I'm asking you whether the services of Mr. Ngobeni was engaged in respect of the Vrede matter post the Talmay judgment. Not whether Advocate Botes did this or Advocate Sikakane did this or any other advocate did this. I'm asking you whether there was instruction, whether Mr. Ngobeni had any involvement post the judgment of Talmay J in the Vrede matter, a matter in which you were integrally involved in.
Yes, and my response is I can't recall, but what I know is that we engaged the services of Advocate Botes to file an argue leave to appeal.
So
I'm not sure
you
at
can't,
what stage did that happen.
Given your lack of recollection, you can't deny that Mr. Ngobeni was involved in providing work-related product and who was consulted in respect of the Vrede matter. Is that not so?
I said my recollection is that we had Botes and Sikakane when we went to the Concord.
No, that's not the question I'm asking. I'm asking you whether his services was engaged to render any work, whether he did the draft behind the scenes, he doesn't appear in court, whether he provided advice, opinions, inputs, media articles, anything of that nature in respect of the Vrede matter.
I can't recall.
Right. Now, because you can't recall, you can't dispute that Mr. Ngobeni's services would have been used in the Vrede matter. Would that not be so?
Chairperson?
No, my answer is I can't recall that.
Chairperson?
Thank you, Mr. Sitole. Yes, Advocate Mpofu.
Yeah, well, I know you say you don't know what's happening, but I can tell you what's happening. This is now.
I did not say I don't know. I know what's
Oh,
happening.
okay. Well,
Please,
okay.
it's,
I know.
it's you who asked
Sorry,
the
I'm
question.
saying, okay, it's me. I'm saying you don't know what's happening. It's cross-examination, Chairperson.
Sorry, please repeat what you said, Advocate Mpofu. What are you saying?
I'm saying what is happening now, if you don't know, is full-blown cross-examination. Once you say,
Speak for yourself.
that's not what
Advocate
I'm
Mpofu.
asking, this is what you ask and what.
Advocate Mpofu, speak
You
for
can
yourself.
ask someone.
Don't speak on my behalf. Don't speak
No,
on
I'm
my
speaking.
behalf.
Okay, sorry about that. I'm talking about my behalf. I'm telling you what's happening. It's called cross-examination.
I
So-
don't need that. Is that what you're raising a hand for?
Yes, I'm objecting. What do you mean was that?
Objecting to
I'm
what?
raising my
What are you objecting to, Advocate?
I'm
Mpofu?
objecting to the ongoing cross-examination of the witness by Advocate Bauer. You mean you haven't understood what my objection is?
Advocate Mpofu, I'm again making a ruling that Advocate Bauer is going to continue what she's doing in terms of 616 and 617. Your objection is noted. I'm ruling that she continues. Please.
But Chairperson,
Thank you.
616 and 617 doesn't allow for cross-examination. That's the point I'm making. I think we're on the same side here. I'm saying.
Thank you, Advocate Mpofu.
Yeah, no, don't thank me. I've not finished. I'm saying that the 616 and 617 that you're relying on does not allow for cross-examination, which is what is happening now, if you don't know.
That's not cross-examination. This is not cross-examination. Thank you,
What is
Advocate
it?
Mpofu. He
What is it?
continues to ask questions arising out of your
Yeah,
cross-examination.
cross-examination is made up of
Members,
questions.
don't speak whilst I'm speaking, Advocate Mpofu.
Don't shout at me
Please,
now.
because I
man.
don't do that when you speak.
Don't shout at me. I'm telling you that this is
Do
cross-examination.
not speak
Chairperson.
Advocate Mpofu, whilst I'm on
Chairperson.
the platform. Don't do that.
Okay, my hand is
I'm
up. Can you
speaking,
allow me?
Advocate Mpofu.
So I
I'm
apologize,
speaking.
Chair. Chair, I apologize. My hand is up. Please recognize me.
I am making a ruling, Advocate Mpofu, that
Yes.
Advocate Bauer is going to continue asking questions arising out of your cross-examination and questions from the members. That's where we are
No,
since
Chair-
this morning, and she's going to continue doing that. Your objection has long been noted, and I've made a ruling in that regard.
No,
Let's
but
not
Chair-
go back to that again.
Okay, can you allow me to talk now?
Thank you.
Are you done?
Yes, you can speak.
Can I
Yes,
talk
you
now?
can
Thank
speak.
you. Okay, thank you. No, Chairperson, I know that about the ruling that you made an hour and a half ago. I'm saying that this objection is not the same as that one, because I'm not a prophet. I didn't know about this last question. This is about just this last question. So I'm saying the last 2 or 3 questions amount to cross-examination. That's all I'm saying. It's got nothing to do with whatever happened before. Okay, so if you are saying this, what has just happened now is not cross-examination, then you must make a fresh ruling, I'm afraid, because the one of 1.5 hours ago doesn't apply to the question that I'm talking about now. Thank you, Chairperson.
Thank you, Advocate Mpofu. I have not picked up any cross-examination, even in the last question. Please continue, Advocate Bauer.
Thank you.
Mr. Satol, I'm putting to you that you actually well aware that Mr. Nkubeni rendered services in the Vrede matter, and you're not making a full disclosure to the committee.
I can't recall if he
Like to
did.
comment on- Sorry, Mr. Satoli?
I can't recall if he did. That's my response.
Now, when you scrutinize the CNAGO invoices for payment, do they comply with the PPSA tariff rates?
Yes, some do, some did not. Some were turned back, which did not comply with the rates.
And did you approve those invoices that didn't comply with the rates?
I'm sure there must have been others which we approved, which might have not complied with the rates. And it's most likely won't be Sianeho only.
Right. And had this been brought to the Auditor General, that might very well have had an impact on that clean audit. But let's move on.
No, Chairperson, I think that's ridiculous. Chairperson,
I've not recognized you. You can't just speak and then raise a hand after that. There's a process that we follow here,
so
and
what
I'm
must I
alert
do?
process all the time.
So what must happen now, Chair?
You must raise your hand.
It's there.
And then I acknowledge you.
Okay.
I now acknowledge you, Advocate Mpofu.
Thank you, Chairperson. Chairperson, you know, I know it's probably out of frustration because the case is collapsing, but we're not going to allow Advocate Bauer to now make snide remarks about the public protector and about a clean audit. You can't erase the 3 clean audits now by snide remarks. If you want to question this witness or declare her whatever you want to declare him, then you must do so about an invoice that he says was not paid even. That's fine, be my guest, but don't withdraw the line, Chair, where you allow her to make snide remarks which are indirectly aimed at the public protector. That we're not going to by anybody, under any guise and out of any form of frustration. Thank you. She must withdraw the remark about about the clean audit, because we must recognize we have the reigning queen of clean audits, 3 in a row, whether you like it or not.
Thank you, Mpofu. I have noted your point. Advocate Bauer?
I made no snide comments about the public protector. As far as I'm concerned, under the Public Finance Management Act, it's not the executive authority that's responsible for clean audits, but that's a question for argument. So let me make this very clear.
If she wants to give evidence, she can go into
No,
the
I'm
witness.
sorry.
Advocate Mpofu? No, please. I can't allow that dialogue. Advocate Bauer?
Let me also say this. The witness I put to the witness that he authorized invoices that did not reflect the PPSA tariff rates. He accepted that he approved invoices that was not consistent with the PPSA tariff rates. That would amount to expenditure that would not comply under the PFMA Act and would, in the greater scheme of things, potentially impact on a clean audit if that is brought to the attention of the Auditor General. That was the context in which I said it.
Chair, my hand is up.
I'm happy to ask the witness whether he agrees that where invoices are authorized which do not comply to the requisite PPSA tariff rates, that is potentially expenditure that is not consistent with the Public Finance Management Act. And Mr. Satoli can then answer it.
Chair, my hand is up.
And can I also place on the record that we've been at this for an hour and a half, of which at least more than a half an hour has been
Please
premised.
ask the witness, Advocate Bauer.
Mr. Satoli, do you hear the question?
No, Advocate Mpofu can't do this.
Yeah, but my hand is up. What can't do? We can't do what?
This is now, it's really tantamount to disruptions of the questions that Advocate Bauer is asking.
I can't object
with me to do this. I'm giving you hand in almost every minute. That's not
true. No, Chair, that is not true. That's a lie, that one. It never, which every minute.
Advocate Mpofu, I am not interested. I'm not interested in your flowery language. We're here for an
my
inquiry.
hand is up. You should be interested in my hand.
Don't even insist, because I don't have to give you to speak.
I'm insisting. It's my right. I'm insisting. It's my right.
Sorry, Advocate Mpofu. Advocate Mpofu.
Right.
At some point, I want to ask you to respect this parliamentary process.
I respect you very
rights,
much.
because your rights will be subjected to this parliamentary process. Okay. Advocate Dalim Mpofu. Advocate Dalim Mpofu.
Yes, Chair.
I'm not going to do this for this day, because I will have to come to a particular point.
My hand is
You've
up.
raised your hand. What do you want to say?
Thank you, sir. With the greatest respect to you and your holiness, I'm saying, Chair, that the two things. One is this, at least if you have time to waste, I don't. I'm not here for the impeachment of Mr. Sitole, which this is now turning out to be. That's the first thing. The the second thing is that the issue about just let me finish. The issue about my objection is based on the unfounded snide remarks about the clean audit. Because how can, even on the logic that is being presented to you, which you are accepting holus bolus, how can a clean audit be affected by an invoice that on her version was not paid out? Where does that come? Which PFMA in which country can do that? So if you want to waste your time, fine. If she wants to waste her time, fine. But I have to place my objection and I have a right to do so. It's not, I'm not asking you for a favor. Thank you, Chairperson.
Thank you, Honorable Mpofu, for your objection is noted. Honorable Ngola.
Thank you very much, Chair. I think we have been listening to this kind of interaction that Advocate Mpofu is always objecting. I think you have made it clear, Chair, that 6.16 actually determines what then must happen after members have actually asked questions or cross-examined the witness. But I think beyond that, Chair, actually from 6.16, it does not determine how long should those questions from the evidence leaders take, and it does actually not regulate on what form and what kind of questions that are supposed to be asked by evidence leaders. So I really do not think that there's an issue about the evidence leaders asking questions. Whether Advocate Mpofu wants to say it's a cross-examination, it's a discussion for another day. But equally, I think part of what I as the member of this committee does not want to take kind is the manner in which Advocate Mpofu expresses his discontent. I really do not have an issue with him raising his discontent in respect of the proceedings of this inquiry. But I think how he does it, I really have a problem. He interjects anyhow, he speaks anyhow, he shouts anyhow, he does not want to be shouted at, he shouts people, he has been doing that. I think, Chair, as much as we are to respect each other, but I think let's have boundaries in terms of respecting the authority of the Chair, so that we have got a seamless process. There is no one, Chair, here who's speaking about a case that is rising or collapsing. That is not for the committee, this committee to deal with. What we are here to do as public representatives is actually to get evidence from the witnesses that will actually enable us as this committee to determine whether what is contained in the charges is actually true or incorrect. So I want to plead, Chair, particularly with Advocate Mpofu, that let's be patient. It's fine to raise a discontent, but the manner in which discontents are to be submitted in this committee is very important. There is the public here that is watching us, that is interested in the proceedings of this committee, that wants to see justice being done, whether for the motion or whether for the public protector. So we won't do that if we exchange words in this manner. So I want to plead, Chair, that we proceed seamlessly and respectfully. Thank you very much.
Thank you very much, Honorable Ngola. The points you have placed are well taken and very important. Advocate Bauer.
Yeah, I'm going to place on the record that we've been now at it for an hour and a half, of which a considerable amount of time has been spent on Mr. Mpofu raising objections.
Can you continue the witness?
Chairperson, that's not true, and my hand is up. I want to respond to Honorable.
I have ruled that the evidence leader continues with the witness.
Chairperson, I have a right to speak here. Do you understand that? I have to speak.
So,
People, if
Okay.
people,
Yes, you have a right. Yes, you have a right. You have a right.
Mr. Ngola just
Sorry,
You have a
Advocate
right to
Mpofu.
speak, but through the
Advocate
chairperson,
Mpofu.
Advocate Mpofu. Don't
You too.
disrespect
Advocate
this
Mpofu.
Yeah,
inquiry.
you too.
Don't disrespect this
Just
inquiry.
mute
Don't
Advocate Mpofu,
disrespect
please.
us. We have been patient with you. You are disrespecting us. You are testing our patience.
Thank you,
don't do
Honorable
that.
Ngola.
Don't do that.
Thank you, Honorable Ngola. Advocate Bauer, please. Advocate Bauer. Advocate Bauer, I want you to continue with the witness.
Mr. Satauli, my last question to you was not based on the invoice to which I referred on the schedule. I put the proposition to you as to whether there were invoices that you had approved which did not comply with the PPSA tariff rate. And you confirmed that.
Okay. So, sorry, Nazreen, Advocate Bauer. Mr. Gyangi, my hand is up.
I have not recognized you. You don't do that, Advocate Mpofu. I've been telling you all the time.
I
You
don't
do that. You don't do what you're doing. Stop what you're doing, Advocate Mpofu. Advocate Bauer.
For the fourth time. Mr. Satauli, I put the proposition to you unrelated to the invoice reflected on the statement as to whether you had approved invoices which did not comply with the PPSA tariff rates. And you indicated that there may well have been some invoices that you had so approved. Did I understand your evidence correct?
Yes.
I then put to you that if invoices, now let me put it to you, I didn't put it to you, let me put it to you, where invoices are paid out subsequent to approval, which do not comply with the PPSA tariff rates, and that would not be consistent with the Public Finance Management Act. Would you agree with that?
I would.
And I then put it to you, or let me put it to you this way. That had not been brought to the attention of the Auditor General. Am I correct? You did not bring that to the attention of the Auditor General.
No, that's not correct, because audit is done in a specific way, and they will when they do an audit, they audit invoices for a specific period, so they won't ask for all invoices. So they will sample, for example, say in the panel, they will sample about 4 firms and do invoices for those 4 firms. And actually, I think there's one invoice that was picked up by the AG, which did not comply with our rates, and the service provider refunded us the balance of that.
Right.
So it's not correct that it brought to the attention of the Auditor General.
Right. Let me put it to you this way. The Auditor General then provides a note to the PPSA in respect of audit queries that are raised. Would that be correct?
Correct.
Were there any audit queries raised in relation to any of the CNAGO invoices?
Not to my recollection.
Just a pause. Yes, Advocate Mpofu, I see your hand.
No, it's fine, Chair. I'll come in. If that's the last question, I'll come in afterwards. I don't want to interrupt her.
Sorry, I don't understand that.
No, I was saying if Advocate Bauer just said that was her last question, so I was going to say if you can.
No, that's not my last question. I didn't say that.
Oh, okay. Okay, then thank you, Chair. Thank you. All right, then let me speak now then. Okay, sorry, I thought it was. I apologize. Thank you, Chair. I just want to address this. I don't think there's any need for anyone to shout, including Honorable Ngola and yourself, Chairperson. I'm making points here which are important, and I'm doing it only to place them on the record because I know the outcome of whatever I'm going to say. This is the situation, Chairperson. If you just give me 1 minute. The directives which you have passed and to which we have objected and which you have passed are the ones that determine the process, not the shoutings of Honorable Ngola. 6.7 of the directive says, Chairperson, the evidence leaders may, in presenting evidence, ask any questions, including leading questions to any witness. Right. 6.8 says, After the evidence leaders have presented the evidence of a witness, the public protector may cross-examine that witness, right? 6.9 say thereafter members of the committee shall, subject to the directives, indicate chairperson whether they wish to pose any questions. And then the chairperson shall determine and so on. And then 6.16, which is the one that is being abused now, says after members have posed questions, the evidence leaders may ask any questions arising or seek clarity from the witness in relation to questions posed to such witness, whereafter the chairperson shall excuse the witness from the hearings. Okay. Nowhere in your own directive, the evidence leaders do not have the right to cross-examine anybody, even the public protector. They, according to this document, unless if you are going to amend this document, there is nowhere which allows them to cross-examine any witness because they are evidence leaders. They're not prosecutors, whatever. Well, they're not supposed to be prosecutors. Doesn't matter how they actually behave here. So that's the only point I'm making, Chairperson. That's why I was saying to you, if you overrule my objection, the only basis upon which you can overrule it on these rules is if you disagree that what is happening is cross-examination. And I was telling you that it is. Now, you may, that's a point about which you may hold a view or someone else might hold a view. But let's not misrepresent what the rules allow or disallow. There is nowhere where the evidence leaders are allowed to cross-examine anybody, nor the members of the committee for that matter. It says they may ask questions, which we know what that means, just like we may ask questions from our own witnesses, which we are going to call, but we wouldn't cross-examine them. That's all I'm saying. Now, I'm not here to give lessons, but I'm just saying that that's the narrow focus of my objection, Chair, is simply that what has been happening in the past 2 hours or so is the cross-examination of this witness. He has even been told that he's misleading the committee or whatever. When someone says, I put it to you, you don't put it to your own witness. That's a hallmark of cross-examination, because that's confronting the witness with a particular question. And it is called cross-examination in anybody's language. That's all I wanted to put place on record, Chair. There's no need to shout about this. It's just a...
Thank you. Thank you, Advocate Mpofu. And thank you for going back to the directives. You have correctly quoted all of them. Your objection that this is cross-examination is noted and it's declined. I want to proceed with my ruling that Advocate Bauer continues with asking her questions.
Chair, before I do so, with reference to the directives, may I point you so that this can be put to bed permanently? Under 3.3, it says, the evidence leaders will present the oral, documentary, and other evidence before the committee in accordance with the rules of the Assembly, the terms of reference, this directive, and any other directives that may be issued by the chairperson. The terms of reference provide in paragraph 5 that the inquiry is inquisitorial in nature and the evidence leader does not act as a prosecutor. The role of the evidence leader is limited to presenting the evidence and putting questions to the PP or other witnesses with the aim of empowering the committee to assess the merits of the evidence in line with its mandate. The format for questioning, whether oral or by way of statement with a view to limiting issues in dispute, is determined by the evidence leader in consultation with the chairperson. Now, I'm endeavoring to empower the committee to assess the merits by pointing out the flaws and the inadequacies of what this witness has told this committee. And I'm coming to it if I would be afforded the opportunity to complete the questioning of this witness.
Which is what I've done. Please continue, Advocate Bauer.
Okay, Chair.
Advocate Mpofu.
Yeah, sorry, Chair, I promise this is going to be short here. All I'm saying is that what Advocate Bauer has called to show the flaws of the evidence of this witness, I might not be quoting a verbatim, is called cross-examination. That's all I'm saying. Thank you.
Thank you, Advocate Mpofu. Advocate Bauer, please continue.
Mr. Sitauli, the point I was making was that the Auditor General, in the form of the audit that he took, had no regard to the invoices rendered by CNAGO. Would that be correct?
I'm not sure if I get that.
Now, I want to move on the point that your evidence in direct examination was that the selection of the attorney was your choice.
Can you go back to the previous question? Let's see, I didn't get it.
Well, in the course of the exchange between us in which you explained the Auditor General's process, I said to you that in the audit report that was submitted by the Auditor General subsequent to its examination, there was nothing raised in respect of the CNAGO invoices.
And I said, yes, to my recollection, no, I don't
Yes.
think it was.
And so I put to you that there was nothing found by the Auditor General in respect of those invoices in respect of where the PPSA rate had not been complied with.
Yes, if that was not picked up by AG.
Right. Now, you were also asked, well, let's go to the start of this. Under direct examination, you indicated that the selection of the attorney was your choice from the
Correct.
panel, right? Let's accept that we're talking about attorneys from the panel.
Okay.
Now, when you change attorneys matters and you go from one attorney to another, that is also your choice. Is that what you're saying?
Correct.
So when TGR gets replaced by CNAGO in the CASAC matter, that is your choice,
Correct.
right? You then indicated in your evidence that today that there is an equitable distribution of work between the attorneys on the panel.
Correct.
Now, you recently received a communication from an attorney on the panel to which you responded when the attorney indicated you that they were not on the panel and that they were on the panel and they received no work. Do you recall that?
Yes.
And you responded to that email.
Correct.
And what was your response?
I will have to read it, but in a nutshell, I think I said there's no enough work at this stage. And I think the SC is referring to the new panel and not the old panel.
Now, there has been a
In
panel
the
that's
new
been in
panel,
existence.
in the new panel, there's probably only 3 or 4 firms that have received work. And I think we have 36 currently, if I'm not mistaken.
Now, Mr.
Okay,
Satauli,
before we proceed, Honorable Gondwe.
Through you, Chairperson, can I request Advocate Bauer if she makes reference to any emails?
I
or
can't hear
documents?
you even as I'm sitting here.
I said, can I request through you that if Advocate Bauer makes reference to any emails or documents and the like, if she could flag them for us so that we are on the same page.
I don't have it. I was apprised thereof by Mr. van der Merwe yesterday that there was a query by an attorney on the panel to which Mr. Satauli responded. And I'm raising it in the context of where he had indicated to the committee that there was an equitable distribution of work today. So I will endeavor when Mr. van der Merwe comes and gives evidence timeously to provide that to you if Mr. Satauli provides it.
Sorry, SC, is the distribution of work qualified by today I don't think that's what Honorable Mola meant. I think he meant was that distribution, I mean, equitable distribution of work to the attorneys.
Yes. The question was there an equitable distribution of work to the attorneys on the panel?
Yes. And I suppose that will be the old panel, because the new panel I think there's only 4 firms that have received work. So by equitable, I will suppose that refers to the old panel, because most instructions that form part of this motion relate to the previous panel, unless we also deal with the evidence of things that happened yesterday.
Okay, I see a hand on the virtual. Yes, Advocate Mbov.
No, it's fine, Chair. I think I'm covered. The witness has clarified. I also understood the issues to do with the old panel, but also I wanted to also say that if that email that is being referred to is available, or when it's available, can it also be provided to us? Because I've also never, I don't know, but whatever Advocate Bauer consulted about this witness yesterday with Mr. van der Merwe or whatever, that would be new. I'm presuming that's after she finished the evidence with him. So that's obviously new stuff. Yeah. So, but we'll deal with it if and when. Thank you. Thank you, Chair.
Advocate Bauer.
Mr. Satauli, on your affidavit, we dealt with a panel of attorneys, correct?
Correct.
As I understand it, there was a panel appointed in 2018. Correct?
Correct.
Right. And there was subsequently a panel appointed in 2020.
Correct.
Right.
December 2020. Yeah.
Yes. Right. The question of the amount of briefs or work that is distributed to the various attorneys arose in the context of the 149 million that was spent. Yesterday, you were asked who gets the lion's share of the work. Do you recall that?
Yes.
In fact, it was put to you that Cianego gets the lion's share of the work, and you disputed that.
Yes, I don't think it was put to me, but the question was, why does it seem that Cianego get most of the work?
Right. And you then disputed that Cianego gets the lion's share of the work.
Yes, on the basis that there are other firms that have received work. Some have received more work than Cianego.
When you say more work, are you saying more different cases or more quantum earned?
More different cases.
So you don't dispute, and we'll come to this, that out of the 149 some million that's been paid in legal fees over the period from 2017 onwards, Cianego, and I say this qualified, including all the cost and council's fees, by far earned approximately 49 million rand of that amount over that period, whether you're part of the old panel or whether you're part of the new panel.
I think that should be correct, SC. I'm not sure if you sent me the totals, but I wouldn't dispute any amount.
It was forwarded to you from I forwarded you the confirmation from your finance department, but I will leave that evidence again. Let me put to you the runner up to that, earned 14 million.
Okay.
Thank you. We will take a 15-minute break for tea and we'll resume at 11:15.
Recording stopped.
I'm here, Chair.
Thank you. Advocate Bauer.
Mr. Sitauli, I think before the adjournment, you were in the process.
Just pause. Advocate Mbofu, you have a hand up.
Sorry. So, no, I'm sorry, Chairperson. It was before lunch. I forgot what it was about.
Okay, thank you. Advocate Bauer, continue.
You were before the adjournment endeavoring to explain your answer in the context of the old panel and the new panel. Could you just repeat what you said?
I was saying in terms of distribution of work for the previous panel, my answer was in relation to that there were other firms that received work, and you asked me whether in terms of money or a number of instructions, and I said number of instructions, and then you were on the amounts before we adjourned for break to say the lion's share of the amount went to Sianeho.
So are you qualifying your statement to say that when you testified that there was an equitable share of work, you were only referring to the old panel, and that in respect of the new panel since 2020, there has been no equitable share of work?
Correct, because in terms of the new panel, we only gave instructions to a very few firms.
You would only give instructions to what?
To a very few firms.
Few firms.
So there are 38 law firms on the new panel.
Correct.
And you only choose a few firms.
Yes, there hasn't been much work to be given to law firms because, as you will know, we've cut down on some of the litigious work, and in fact, the litigation that is still pending is instructions that were given to the old panel at the time when that what do you call that contract was still running.
So are you saying that from 2020 onwards, you did not distribute briefs in an equitable manner?
Not distribute in an equitable manner. There hasn't been much work to be distributed.
Now, Mr. Satauli, please listen to the question. Whatever work you got in since 2020, whatever new matters you got in since 2020, are you saying that you did not distribute the work you got in from 2020 in an equitable manner?
From January 2021 up to today. Yes, because from 2021, I think we really appointed external attorneys to oppose review applications. And the issue of equitable distribution will not apply to the new panel because I can't say we have received or we have received the, say, 36 review applications, which we can distribute to each and every firm in our panel. And also the issue of distribution also depends on where the matter is. You might have 40 law firms in your panel, but you have 10 firms that
Okay, we're checking if they're back. Are you back on YouTube? Thank you. We now proceed. Advocate Bauer.
Mr. Sitauli, the relief sought in the Baloyi matter has got nothing to do with the Enquiry matter. It's got to do with the employment relationship. There's no declaratory relief sought in the Baloyi matter relating to the Enquiry matter.
No, SC, the Baloyi matter relates, there's allegations raised there that the PP interfered with the investigation of the Enquiry matter. So it's not a pure labor matter. There's more issues to it than labor.
Sorry, Advocate Bauer, I hand again. Advocate Mpofu.
Chair, well, okay, two quick things. One is, I don't know how you are operating today, Chair, because now we're going towards lunchtime on so-called 6.16, and you have not, yesterday you allowed half an hour for this kind of thing. Now it's going on for almost 3 hours. So I don't know whether you are intending or you just want to do it, allow it for as long as Advocate Bauer wants to do it, or whether there is any possibility of us getting into the witness that we were told is going to come today. So the first point is about time, if there's any time restrictions. I suppose there isn't any, but I'm just asking. Yeah. The second issue deals more with what is being asked now about the Baloyi matter, and that I just thought maybe it would be easier to go to the notice of motion in that matter, so that we don't waste time on this, so that we can see the constitutional declarators that were sought apart from the labor matter. Thank you, Chair.
Thank you, Advocate Mpofu. Your concern is valid. Yes, there is time restriction, and I would have asked Advocate Bauer to go towards wrapping up because we are going towards the second witness. I'm hoping that because part of her time has been interrupted continuously. So that's part of the challenge, and I'm hoping that we will all allow her to conclude on the remaining questions. Yeah, Advocate Bauer.
Chair, the witness beforehand said the declaratory relief related to the Enquiry matter. I put to him
No,
that the
that's
declaratory
not what I said. I'm being misquoted there.
Okay, Mr. Sitole.
That's not what I said, Chair.
I recognize you.
Thank you, Chair.
Can we
No,
go, Sitole?
I was clarifying, Chair, that that's not what I said.
Yes, please do. Please do. Go ahead.
Yeah, no, Chair, it was just a clarity that that's not what I said. I said it's a declaratory order that related to other issues, which include the PP's interference in the Enquiry matter. It was not that the declaratory relief was about the Enquiry matter.
Okay.
Thank you, Chair.
Thank you.
If I was allowed to finish, I would have said that was his clarification after I understood his answer in the first place. Right? Mr. Sitauli, I'm going to, when the evidence is done, reflect with reference to the allocation of cases that in a number of instances or relating to the cases on the mandate specifically, and I'll draw you to 3 cases in specifically. In the CX matter, when it related to the substance of the litigation, you would agree CNAGO had no involvement, correct?
Correct.
When it came post litigation and post-constitutional court litigation, and a legal opinion was procured, the instruction was given to CNAGO to procure that legal opinion, correct?
Legal opinion from who?
From Advocate Mgilwani and Advocate Karachi in respect of post the constitutional period. What to do with the order subsequent thereto. There was a magnus opus costing you a significant amount of money, over 288 pages in total, for which CNAGO briefed counsel in the CX APSA matter on your instruction.
Is it the opinion I sent to the SC
Yes.
recently?
That's correct.
No, I think that refers to the advice on whether the PP can reinvestigate the CX and not necessarily the judgment, if I get you correctly.
No, I didn't say it related to the judgment. I said it was issued post the constitutional court judgment,
Okay.
that you
Yes.
obtained the legal opinion.
Yes.
And you used the services of CNAGO to obtain that opinion,
Correct.
correct?
Correct.
In subsequent to that period, you obtained an opinion in respect of crowdfunding relating to the order emanating from the constitutional court judgment, correct?
Correct.
And you used the services of CNAGO to obtain that opinion, correct?
Correct. Correct.
In the Gordon matter relating to the pensions Pillay matter, you initially instructed the attorneys firm of VZLR to deal with an opinion in that matter. In fact, you see that because that instruction is attached to your affidavit. Mr. Mpofu, Advocate Mpofu referred to it in cross-examination.
Correct.
You then replaced VZLR with CNAGO.
No, they were not replaced. They were only engaged to source the opinion from a counsel, which they did. So their instruction was only to get the opinion and not to take it further if the advice is something else. And the reason for that is that the opinion was relating to an investigation and not a report that had been finalized.
The point I'm endeavoring to make is that you obtain an opinion from one law firm. When the litigation commences, you go back to CNAGO. This is all during the mandate period. So now I'm asking you, why did you not engage VZLR to continue the matter?
As I said, they were engaged to get an opinion in respect of the Pillay pension matter. And as you correctly say, in litigation, we then engaged CNAGO and we engaged Advocate Mpofu. That opinion was provided by Advocate Ngalwana, but we chose to not brief him on the Pillay matter.
Yeah, I'm not talking about the briefing of counsel. I'm talking about the instructing of attorneys.
My answer relates to both SC.
So are you saying that a condition to the briefing of Advocate Mpofu was the instruction to CNAGO attorney?
No, I'm saying VZLR was appointed to render an opinion on the pension scheme of Mr. Pillay, which they briefed Advocate Ngalwana to render that opinion. That opinion related to an investigation that was ongoing. The investigation was finalized, and then a few months later, that report was issued, and a few months later, it was taken on review. We appointed CNAGO, who briefed Advocate Mpofu to argue the matter.
Yes, but that's the point I'm trying to make, Mr. Sitauli, is why did you go back to CNAGO when they were already on brief in other litigation matters? Why did you not spread the work to other attorneys on the panel?
Other attorneys had work on the panel, so it's a discretion issue that we felt Sianeho will best deal with it.
So now I'm going to ask you in respect of the Pillay matter.
Yes.
Did Mr. Ngubeni provide you with any work in respect of the Pillay matter, in respect of any of the Gordhan related matters?
I'm not sure, SC. Can I be assisted maybe with, you can flight something that can refresh my memory?
I don't have anything to flight. I'm asking you. You've gone back to CNAGO attorneys, and I want to know whether in the course of the Gordhan related matters, you know, we saw the fee note in the Lord Law matter, which is related to the Gordhan matter, which refers to Ngubeni. And I'm asking you whether Mr. Ngubeni had rendered work in the Gordhan matter.
I'm not sure, SC. He might have not.
What does that mean? He might have or he might not have.
Yeah, so it means I can't say it out of my head. If I was assisted maybe with something that can refresh my memory.
Well, there was a judgment from Judge Potterell, right?
Yeah. Yeah.
Did you receive any work product from Mr. Ngubeni in respect of the Potterell judgment?
I think he made commentary. He made commentary on that judgment. SC. I'm just not sure if in respect of litigation he produced anything, but I know he made commentary. I think there's also an email he sent to the Chief of Staff regarding that judgment.
Was he provided with the court papers in the interdict or in the review application or in any aspect in relation to the litigation matter?
Possible, yes.
And why would he have been given that, Mr. Sitauli?
I'm not sure.
Would you have given it to him, Mr. Sitauli?
I'm not sure. That's why I asked to be assisted, maybe with the emails or some form of evidence to refresh my memory.
So I'm going to put to you, Mr. Sitauli, that in both the Vrede matter and in the Gordhan Pillay matter, services was rendered by Mr. Ngubeni, and the reason why you switched attorneys to CNAGO was partially to ensure that you could pay Mr. Ngubeni in respect of that work. And what is your comment in respect of that?
I don't remember paying Mr. Ngubeni for service rendered in respect of litigation.
You can't remember any services at all being rendered by Mr. Ngubeni in respect of any litigation matter, or just these two?
I can't remember paying Mr. Ngubeni in respect of any litigation.
Now, Mr. Sitauli, we've already established you pay CNAGO and CNAGO pays on. So you don't pay any consultants directly. The proposition I'm putting to you-
Yes, SC, but remember that the evidence you flighted will include Advocate Ngubeni's invoice. I'm speaking in that context.
Now, I don't know whether CNAGO absorbs Mr. Ngubeni's cost into the invoices as services rendered by them, or whether they attach their invoices separately. I don't have that information.
Them.
All I'm asking you, Mr. Sitauli, please answer the question whether you had received any work product from Mr. Ngubeni in respect of that matters.
I don't remember that. SC.
Did you receive any work product from Mr. Ngubeni in respect of an opinion relating to the Waterkloof airport matter and in respect of the Zondo Commission?
I'm not sure. It's possible. I'm not sure.
So we've shifted away from.
Are they not included in the emails in the opinions I gave to you? Those two.
No, Mr. Sitauli, we've already established there were only 3 opinions. That was your evidence earlier on today. I'm now asking.
Yeah,
you
I
in
said I
respect-
remembered those 3 opinions.
Is there now another opinion in relation to the Waterkloof and Zondo Commission matters?
I am not sure. I see. I'm not sure.
It is so, Mr. Satauli, that I'm going to put to the committee that your failure to remember things is a failure to make full disclosure to this committee. And I want you to be able to comment on that to this committee. I want to give you the opportunity to comment.
Well, I can comment by saying when evidence was led the first time, I was given evidence upon which I must respond to, especially in respect of Mr. Ngobeni. And evidence was flighted on the screen. I was tested on the evidence that is there, and I responded on that evidence. Secondly, I provided information to the evidence leaders to the best of my knowledge. Some of the evidence I did not provide it to them the first time, not because it was withheld, but because it was discovered later, or I remembered later that it was omitted with the first batch. So there is no evidence that I would have deliberately withheld from the evidence leaders. Everything that I say I do not remember, not because it's deliberately withheld, it's simply because I simply can't remember. And I'm happy if the evidence leader flights on the screen that on this day you received this from Mr. Ngobeni, on this day you send this to Mr. Ngobeni, then I can confirm. I can also add, Chairperson, that yesterday I said to the evidence leader, Advocate Ngobeni provided an opinion on the appointment of special advisors, and I was incorrect because that opinion was done by Advocate Shakwan. So it cannot be that now I'm being painted as a witness who's withholding information directly from the committee when I have no intentions or no benefit whatsoever. It has already been established, Chair, that Advocate Ngobeni has been used to render services to the PPSA. It has already been established. What is it that I'm going to gain by withholding information in respect of Advocate Ngobeni? If it is inhuman to forget, Chair, then I'm happy that this proposition be put to me to say my lack of memory amounts to a lie. And that is something I'm willing to defend to the T, even if I'm taken to task on it, whether a perjury charge is opened. Because right now, this cross-examination has now become about me than it is about Advocate Mkhwebane. But Chair,
Yes,
I will respond in detail to this at the end. I don't want to cross-examine. I mean, I don't want to interrupt cross-examination.
Mr. Satauli, in the course of our consultations, I did ask you whether there was any other matters, and I said you to go through your emails to see whether you had any other information in relation to Mr. Ngobeni, and you confirmed to me that you did not. Is that correct?
Was that in respect of opinions?
No, it was in respect of any work rendered by Mr. Ngobeni.
I think I said I can't recall. Let's see.
Your evidence was that the only work you can recall Mr. Ngobeni giving was the 3 opinions you put forward.
I can recall correctly.
Your evidence was that you had never met Mr. Ngobeni. That was also your evidence indirect, correct?
Correct.
Can I ask you, your evidence was that you had also received, you had no knowledge of any consultants being appointed.
Correct.
Now, can I ask you, do you know who Kim Haller is?
Yes.
Was Kim Haller engaged as a consultant?
No.
You were not party to any meetings or any conversations or any arrangements for the purposes of appointing Kim Haller as a consultant.
We did attend a meeting, and in that meeting, I think they made a proposal to render consultancy services, but that process failed.
And who attended that meeting, Mr. Satauli?
It was myself, Mr. Mshongo, Chief of Staff, PP, and I think there was also Professor Siepe there.
Sorry, Professor who?
Siepe.
So you have no knowledge of them rendering services for which they were paid by CNEGO attorneys?
No, they were never paid by our office. That's what I know. Because they couldn't
That is
come
not the
through
question I'm asking.
the normal
Satauli?
procurement processes.
You have no knowledge of them being engaged to render services to the PP for which they were paid by CNEGO attorneys.
They were paid by CNEGO, not through us. That's the question.
Yes, I'm not asking you whether they were paid by
I don't
your
know.
office.
I don't know if CNEGO paid them. See.
Yeah, just pause, Honorable Heron.
Yeah, thank you, Chair. And sorry to disrupt. I'm just following I'm struggling to follow. Is Kim Heller a person, or because we started with a Kim Heller and then it became a they? Were they paid? Is it a who? What is that? Thank you.
Thank you, Honorable Heron. Advocate Bauer.
Mr. Satauli, who's Kim Haller?
I wouldn't say I know much about her, but I just know her from. She's in the media space, I think, something like that.
Right. And at this meeting, it was Kim Haller and Professor, what did you say his name was? Sipo
Siepe, yeah.
Siepe. So did they jointly put a proposal to the PP?
I think they did in that meeting. They jointly put a proposal.
So I'm putting to you, did they individually or jointly, to your knowledge, get paid by CNEGO attorneys?
Not to my knowledge.
You have never seen any invoices in which mention was made of them?
I have, see, that's why my question was to you. You mean paid by CNEGO through us? And my answer was no.
Okay. I'm going to move on because I want to get done because of time constraints. Right? Out of the 49 million that was spent on legal services in respect of CNEGO, there were 3 instances in which there was success. Let's just list them for you quickly. There's the Enquiry matter, correct?
Correct.
Then there's the National Assembly Concord matter, which comes up from the High Court that goes to the Concord, in which you succeeded on 1 point.
Correct.
Finally, at the Concord, right?
Correct.
Now, would you agree with me that when you take 10 legal points, the matter becomes more pricey than when you take 1 legal point as a matter of principle?
I'm not sure if I get that.
If you argue 10 items, you have to deal with all 10 items on your affidavits and in your heads of arguments, which entails more work. So it costs more. Do you agree with that as a matter of principle?
Correct.
Would you also agree that in all the issues that you raised at the Concord, which is a number of, I think, 12 challenges, you only succeeded on 1? Your cross appeal failed on the other items.
Is this the speaker matter?
Yes,
Okay.
I didn't get your answer, Mr. Satauli.
No, I was saying yes, that's correct.
It was put to you in cross-examination that there was some sort of strategy adopted in the James matter, right? That paid off. Do you recall that? Mr. Mpofu, Advocate Mpofu raised your litigation strategy in respect of where people other than the PP deposes to an affidavit. And it was put to you that the strategy pointed out, and you correctly pointed out to him that the litigation strategy came out after the James matter had already been concluded. Do you recall that?
No.
In the James matter, the deponent to the affidavit was not the PP. Do you remember
Correct.
that?
Yes.
And Advocate Mpofu then said to you that that paid off because there was no punitive cost order against the PP, and you agreed with him.
Correct.
Now, if you go to the James SCA judgment, and I don't intend to take you there, but there is no question of a punitive cost order having been asked for in the first place or even being considered by the SCA.
Okay.
You agree with that?
I would.
Okay, just before we proceed, I see a hand. Advocate Mpofu.
Yeah, Chairperson, yeah, I'm sorry related to this. What on earth has all this got to do with this inquiry that we're
You asked the
having here?
questions.
I'm not talking to
Are you
you.
done, Advocate Mpofu?
Chairperson, yes?
Are you done?
Yes, I want to know, Chair, really, why you're allowing all this to happen now? I mean, how is it going to help you? In what way? Because I don't know, I really don't know. I'm being serious, whether we're questioning Mr. Stoller or the Auditor General or this one or that one, or Mr. Ngobeni, or are we still on this issue of the public protector?
Thank you, Advocate Mpofu. We are still here.
Oh, okay.
There are questions being raised in relation to some of the questions you would have asked. Advocate Bauer?
I didn't raise the James matter. Advocate Mpofu raised the James matter, and he put it to this committee that the reason why there was no punitive cost order against the PP in that matter was because she wasn't the deponent to the affidavit. And I'm clarifying that there was no punitive cost order sought in the matter.
Okay, proceed.
You also agreed.
Sorry, Chair, can I respond to that?
If it's necessary, yes.
It's very necessary, Chair, because I'm tired.
Go ahead.
Okay, okay. Advocate Bauer is misrepresenting what happened. I said to the witness, it was in relation to the question of the vulnerability, when I was talking about issues of personal costs, the vulnerability of the public protector to such costs. And I said to the witness that in the James matter, the affidavit was not signed by the public protector, which he agreed to. And he pointed out that that matter had happened before the strategy that he said he crafted in, I think, 2020 had been in place. And the only proposition I made, and so I don't know what is the point of Advocate Bauer referring to the question that I made before the witness pointed that out, except to try, I don't know, to show that I asked the question before the correction, which if that's what you want, I own up to it, yeah. But the point to that I then made to the witness was that in any event, in that matter, then the public protector was not vulnerable to a cost order. And my instructions are that those issues were discussed. I don't know whether they're in the judgment or not. I was not involved in that matter, but they were discussed at least during argument I think in the SCA, and that's all really. I mean, but that's not my point. So I'm just assisting about the question because it was my question. But my objection, Chair, that I was raising was about whether there was a cost order in the GEMS matter or whatever. What has that got to do with the work of this committee?
Okay, thank you, Advocate Mpofu. You will clarify it with Bauer,
No,
if you will, and then you proceed with the witness.
there was a proposition put to the witness which was not correct, and he agreed with it. And the question that the proposition was put along the lines, and so the SCA couldn't make a punitive cost order against the PP. And I pointed out that there is nothing in the judgment that reflects there was any consideration or relief sought for a punitive cost order. That was it. I was correcting what was put to the witness and which the witness agreed with. I don't think there's any point in us having a debate about this.
I give up.
I'd like to move on now, Chair, and can we just put this to bed?
I've already asked you to move on once you're done with the response.
It was also put to you, Mr. Satauli, that the Gupta leaks, that the PP's views that the Gupta leaks should be investigated were defeated. And you agreed with Mr. Advocate Mpofu saying, among other, it was defeated. Now, who would have defeated her?
No, I think the word defeat would have been extreme, to put it that way.
No, Mr.
Not the
Satauli.
issue of
But the view of hers were defeated by other views because it could be dealt with at Zondo, quote unquote. And your answer was, among other things, yes. I'm not misrepresenting what Advocate Mpofu put to you at all.
Yeah, I'm saying the word defeated in the proposition might have been extreme.
But you agreed with the proposition yesterday, which is why I'm taking you back to it today.
Yeah, if you put it in perspective, I'm allowed to disagree with the proposition if I misunderstood it yesterday. I don't think I'm disallowed from correcting propositions that I agreed to.
I'm sorry, Mr. Satauli, you froze there for a moment. I'm not sure if you're back with us. And if
No,
the
I'm here,
proposition,
I'm here.
I have no difficulty if you wish to amend your answer that you wish to say yesterday. But the proposition I want to put to you, if the PP felt strongly about something being investigated, then nobody can defeat her or overrule her. Would you agree with that?
I couldn't get you, SC. I think you froze for like 3 seconds.
I said to you, I have no difficulty if you wish to amend your response that you gave yesterday. That's precisely why I'm going there, so that we can get clarification on your response. And if your response is that saying defeat is maybe too extreme a word to be used, is the proposition not the following? If the PP wanted something to be investigated, then nobody in the organization can overrule her to do that. Would you agree with that?
Correct.
You then testified that there was a progressive improvement in performance culture. That was Advocate Mpofu's words, and you agreed with him. What did you base that on?
I think I gave context to my answer. And I think the improvement was in respect of the number of the reports that were issued.
You also agreed with Advocate Pofu when he drew the analogy with judges being guilty of misconduct. I wasn't sure I caught that. What were precisely were you agreeing to?
I can't remember that. Yes. I can't remember the proposition about judges being found to have misconducted themselves.
That if judges don't hand down judgments within periods of time, they would be guilty of misconduct. And you agreed with Advocate Mpofu. And I wanted to understand what was your understanding of the misconduct of judges.
It was not necessarily misconduct of judges. It was an analogy that just like in the judicial system, if a judgment is not issued timeously, the judge president will then rein in on the judge as to why is the judgment taking long to be delivered. And that was based on the analogy that that's why the PP will actually push for results for reports to be issued. And that was in respect of investigators will then be given deadlines on when they must finalize investigations. That is my recollection of that engagement.
Chair.
Yes, Advocate Mpofu, you are recognized.
Yes, no, thank you, Chair. Again, there's an effort to assist. The question I put, and again, I might not be quoting it verbatim. I think I made it clear. I said this based on my experience in the space that I operate in, which includes the judicial space and the Judicial Service Commission and all that. And the point I was making was quite a simpler one than the one that is being proposed, which was that there are deadlines. There's a 3-month deadline, there's a 6-month deadline, and thereafter it becomes misconduct. And I can just say, Chair, while I'm at this, that and maybe if necessary, we'll bring the necessary evidence that at least I presided, well, not presided, but was part of an impeachment, or rather an attempt to impeach judges because they had taken 4 years to issue a judgment. It was in that context, as opposed to here where people are impeached for meeting deadlines. That's all I was trying to portray.
Thank you, Advocate Mpofu. Proceed, Advocate Bauer.
The point I'm trying to make, and the point that was made with this was that the position was that you don't have service delivery without deadlines. And Mr. Satoli, those service delivery deadlines existed even prior to Advocate Mkhubane coming into office. Are you aware of that?
Yes.
Now, you mentioned that at the time when she came into office, and I don't want to belabor this point because I'm going to go back to the document at some point, that there were 25 reviews of reports pending. Did you base that on the handover report that Advocate Stoffel Fourie prepared?
Correct.
Now, I have no further questions for this witness.
Thank you, Advocate Bauer. Mr. Sitole.
Yes, Chair.
I'm just coming back to you. Do you have any comments or issues to raise, having been with us? And you did indicate earlier that you want to say something at the end. That will be the opportunity for you.
Correct, Chair. Chair, I wrote.
Chair, my hand is up. Sorry, Mr. Stoller.
No, Advocate Mpofu, before I'm now with Mr. Sithole, but I will recognize you.
No, apologies, Chair. Sorry, Mr. Stella, for interrupting you. No, I'm saying, Chairperson, I indicated to you in the morning that in respect of the new material that has been raised in this cross-examination or whatever you call it, I have a right to ask questions or to cross-examine. I don't know if that's, if you are, either you are disallowing that, or if you are, you must do it like verbally, because now it looks like you are releasing the witness.
Thank you, Advocate Mpofu. Yes, going to the witness because I think we've traveled this space. There's been no new evidence placed here. That's the first point. And secondly, you did give yourself an invitation to cross-examine, and that is going to be declined. I have not given you that to cross-examine again. So that is now my ruling as I want to proceed to the witness. Thank you.
Thank you, Chairperson.
Mr. Thembinkosi Sithole, I'm coming back to you. I want
Thank
you
you,
to
Chair.
speak to the committee and raise your final comments, any issues that you want to raise. It is your space.
Thank you, Chair. Chair, maybe let me start with clarity first from the Chair. I understand that Advocate van der Merwe must still come in and I must join him in giving evidence on the finances. I just want to confirm if that is still the case and when will that be done, Chair? Maybe before I move to other points.
Okay, thank you for that.
You will recall that I gave you the costing on some of the cases yesterday because we hadn't finalized the costing on all of the cases, and it was anticipated that if there was something that emerged, it would be raised during Advocate van der Merwe's evidence. Subsequent to that, there was a further request from the committee in refining that evidence, which may require a question from the committee that Advocate van der Merwe may not be able to clarify and would require Mr. Sithole's clarification on that in an eventuality. We are we're quite over time. So I can't, on the second question as to when that would be, we have to see where we end by today, and I can maybe revert to Mr. Sithole as to when those figures are finalized, I'll provide them to Mr. Sithole because he's provided input on the other figures that have been finalized to date to do that. And we can then work out whether there's something arising from that that would require his input to the committee.
So what do you say?
That he may or may not be required.
Thank you, Advocate Bauer. Mr. Sithole, yes, in my understanding as a chair, what you are asked to come here for, we have reached that with you. If there's going to be any other request, it's separate from the time that you have spent here. You have done what we ask you to come and do. So if you like, in your own voluntary way, you can be on standby, but it can be that you have not completed what we invited you to do. So that's why I'm coming back to you to take the platform.
Thank you, Chair. Chair, I just wanted to raise a concern about the manner in which the proceedings continued or were conducted today in respect of my evidence. Chair, you will recall that I first came, I think, 2 weeks ago, and I was led on evidence, and then I was cross-examined by Advocate Mpofu. And then today, Chair, what happened today was a pure cross-examination from my experience and knowledge of what cross-examination is. Chair, I have no issues whatsoever responding to questions put to me under cross-examinations, but the issues I want to raise, Chair, are simply the following: that on the evidence that was put to me, the evidence was put to me that was flighted on the screen. Some of the evidence was sent to me from the paginated bundles that the members have. And I was asked on the evidence that the evidence leaders and the committee has. Today, Chair, there's more than one questions where I was asked to speak from my recollection. And I was asked to answer questions on documents that are not in possession of the evidence leaders, that are not flighted on the screen. And based on my comments, there's a comment or suggestion to the effect that I'm not giving truthful answer. Chair, that is a very worrying concern for me and for any witness that still going to come before this committee. Secondly, Chair, the cross-examination today, mostly, if not all, related to my work directly, the kind of work that I do. I will not have had a problem if I'm the one who was undergoing this process, Chair. But you could see that there's even evidence that relates to matters of emails that I sent yesterday, Chair. I sent to an attorney who was inquiring as to why are they not getting work despite the fact that their firm has been appointed in 2020. That's one of the firms that are on the, I think we have 36 or 48, I can't remember the number, but that's not the only firm that has not received work, Chair. But as to why I'm asked on matters that I'm still dealing with as early as yesterday, I'm not sure, Chair. I feel like I'm being managed from outside. I don't know how to put it, Chair, but I'm trying to put it in the most respectful way. Thirdly, Chair, there's a suggestion by the evidence leader that the audit outcome or the clean audit might have been cooked. And that comes from the fact that I've made admission that some of the invoices might have not complied with the rates. And I gave an explanation as to how the audit is done. Also on that, Chair, those invoices were not put on the screen for the committee to see. I was not pointed to even a single invoice where they said, Mr. Stolle, this invoice doesn't comply to the rates. It fell within the audit scope of audit of 2018, 2019, but I was requested to confirm things that I do not see from my recollection. And Chair, all this is done at the back of the fact that I'm an attorney, I'm an officer of the court, I must be honest, I have no problem with that, but I'm happy to give evidence on the evidence that is available that I'm led on or I am cross-examined on. Lastly, Chair, I can assure you, you will not find another witness after me that will speak to matters that even related to the time when there was someone in charge of that institution. Some of the matters relate to a period from May 2017 up to 2019 or early 2020 when Mr. Nemasisi was here. But I was happy to respond to that, Chair, because I gave the evidence leaders information. I put my head on the block. I admitted even wrongdoings that could not have ordinarily fallen on my plate. And I tried by all means, Chair, to avail myself to the evidence leaders in respect of these proceedings. And Chair, to then come and be dealt with in the manner that I was, I must say, Chair, that I'm very disappointed. It's too late, Chair, there's nothing you can do. But for future witnesses, Chair, I will plead with you to be more in control on how witnesses are questioned. I thank you, Chair and members.
Thank you. We'll respond to
Chair.
that. I just see a hand on the virtual. Advocate Mpofu.
Yes, no, thank you, Chairperson. Yeah, no, I think I'm mostly covered, but I just wanted to emphasize 2 points. One, the fact that, maybe we'll bring evidence to explain what cross-examination is. I can understand you, Chair, not or anyone else who's not legally trained, not understanding what cross-examination is, but not the legally trained people. I think they know exactly what cross-examination is. The second one is about the new evidence, Chair. The witness has just referred to an example of some email or whatever that apparently he wrote yesterday. And you just ruled out that there's no new evidence that was dealt with. So I'm just want to show you that factually that is just untrue. And the last point is just to say that I think we share the disappointment of the witness. And if these proceedings are going to be conducted properly going forward, we can't allow for a situation where just because a witness, and I must say that this witness, of all the people who have claimed to be legally trained, he has been the most honest witness and even accepted, took responsibility where he has done things wrong, which is the only person I can say I'm proud to call my colleague in the profession. But for the rest, it's what we call in the township, and there's no room for that here. If the case is collapsing, then it can be done.
As explained that colloquial, the township.
Or I can explain it. No, it's an expression that is directed at someone who is doing something only because of what we call chest pains. When there are,
All right.
and there's no room. I'm just saying, yeah, there's no room for that in this kinds of proceedings. These are supposed to be solemn proceedings, and as I say, Chair, I mean, I'm not being sarcastic. When I was trying to explain what cross-examination is, I was not expecting you, because unlike you, Ms. Bauer and I, you did not sit for 6 years at law school or whatever number of years. But I'm just disappointed that those who should know better are abusing the rules. Thank you.
Thank you, Advocate Mpofu. Advocate Bauer.
Yes, can I place on record that my job is to get to the truth and to put the information relevant before this committee. Now, whether the witness and Advocate Mpofu wants to categorize this as cross-examination, that is up to them. I do recall Mr. Advocate Mpofu earlier on saying the best way to get to the truth was actually through cross-examination. But my purpose is to get to it. Let me also say that a number of the questions that I raised today did not come up in my direct evidence, nor did I have it in my possession or knowledge. I might have had it in my possession at the time, but didn't know about the statement. The witness raised the question of a clean audit. The witness raised the fact that he was equitably sharing out the briefs under cross-examination. The witness raised that to his knowledge, Advocate Nkubeni or Mr. Nkubeni had only given 2 or 3 opinions. The questioning of the witness is in the context of that. The witness was asked to provide the invoice to which that statement reflects, and he said he hasn't got it. Now, the point is, the witness has absolutely wonderful recollection of certain events in 2019, and in the context of which Mr. Nkubeni, and this is what I will put at the end of the matter, it's not for the witness to answer whether consultants were or were not engaged. It's for the public protector to put that before the committee. All I did was ask the witness about his knowledge of that event. It's not based on whether there's documentation or not. The documentation that was put up is the documentation that the witness provided to us or which we got out of the Public Protector's office in the first instance. There are other documentation, and when the Public Protector is called as a witness either by us or chooses to come and give evidence, then we will traverse these issues with the person who is meant to answer to this committee.
Thank you, Advocate Bauer. Mr. Sithole,
Mr. Chair?
I want to, on behalf of the committee, firstly, to thank you for availing yourself before today and before you came here for the first time to be part of this process and assist the committee in a way that is best to your own abilities to assist it. You have spent considerable time with us as a committee. I want to even further to thank you for placing the issues you have placed in your final comment today. All members of the committee were listening to that in registering those concerns. They certainly have been recorded. We are going to take that into account in our own deliberations as a committee. So please rest assured in terms of our own objectivity and application of our minds on those issues. I take further your own suggestions and advice, even to the chair, about future witnesses. It's well taken. I think we, as a committee, want to appreciate the time you'd have spent here. We remain a committee that has no predetermined outcome, that we listen with an open mind. And it is in that context that I appreciated you placing those issues and not just talk about them in corridors and so on. So thank you very much.
Thank you, Chair.
With that, we have reached the end with you, unless there's anything else where we would ask you further information. But for now, you have completed your task. Thank you very much.
Thank you, Chair.
Thank you. And thank you, Advocate Mpofu. I take the comments you have placed here in the committee. We're going to take a 5-minute break as we change into the next witness. Just 5 minutes and then we're back.
Okay.
Thank you. At 28 minutes past, we'll be back.
Recording stopped.
Thank you very much. Welcome back, colleagues. It's now 29 minutes past 12. We now proceed with our inquiry and start very late with the next witness. And for that, perhaps the first thing I want to say to all of you colleagues is that our legal services advisor, Ms. Fatima Ibrahim, has fallen ill. So she was not with us yesterday and today. We pray for a speedy recovery. And in her place, we have Ms. Jackie Millo, who's going to do the preliminaries and introduce our next witness. I now recognize Ms. Jackie Millo.
Thank you, Chairperson. Allow me to pass my sincere greetings to the House at large and all the protocols observed. The next witness is Nelisiwe Gabinde. Our next witness is Nthoriseng Motsitsi.
Oh.
If she's in the virtual platform, can you hear me?
Good afternoon, Chairperson. Good afternoon to the House. Yes, I can hear you.
Ma'am, you have been invited subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislature Act 2004 to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mukhwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that the evidence given under oath or affirmation before a House or a committee may not be used against you in any court or a place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers Act, a person who willingly finishes a House or a committee with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or an imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take an oath or an affirmation. Which one would you prefer?
I'll take an oath. Thank you.
Thank you. Please raise your right hand and repeat after me. I swear that the evidence I shall give
I swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth, and nothing but the truth.
The whole truth and nothing but the truth.
So help me God.
So help me God.
Thank you, ma'am. Chairperson, the witness is now sworn. Thank you very much.
Thank you, Ms. Jackie Millo, for your able task. We appreciate that. And welcome, Ms. Motsitsi Nthoriseng. Is
Thank
that
you.
correct?
Yes, Nthoriseng.
Okay, thank you very much. I now recognize Advocate Ms. Samayos.
Thank you. Thank you, Chair. Good afternoon, members And good afternoon, Ms. Motsitsi.
Good afternoon, Advocate.
Ms. Motsitsi, you are currently the Executive Manager for Complaints and Stakeholder Management in the Office of the PPSA, is that right?
Yes, it's right.
You prepared an affidavit at the request of the evidence leaders for the assistance of this committee in relation to information that you consider may be relevant to its work. Is that correct?
That's correct.
And you stand by the contents of your affidavit?
I stand by the contents.
Before your current position, you've worked in various positions at the PPSA, starting with being senior investigator between 1999 and 2004. Is that right?
Yes, that's right.
And you were chief investigator after that, right?
Yes.
At some point you left the PPSA and you went to work at the Department of Home Affairs, but you came back and you rejoined the PPSA in your current position. Is that right?
Correct.
And you've held your current executive manager CSM position since May 2017, correct?
Correct.
Now, in your affidavit, in the early sections of your affidavit, you set out what your unit does, the Complaints and Stakeholder Management Unit does, and you do say that it consists of 5 branches within the unit, which is intake, assessment, and early resolution, customer service, remedial action, and outreach, and stakeholder management, correct?
Correct.
And you briefly just try to explain what the intake unit does, and that's the unit that receives complaints and processes them through a registry. It gives them a reference number and so on, correct?
Correct.
You then also explain the assessment unit, and you said that this unit is a unit that does a preliminary analysis of new complaints. It's the unit that is involved with the business of classifying the nature of the complaints that are received, correct?
Correct.
And it would then classify them either as early resolution, GGI, service delivery, and so on, and allocate them to the correct unit within the PPSA, right?
Yeah, correct.
So in essence, then CSM is responsible for referring complainants to other bodies as well that may be better suited to handle or investigate complainants' complaints, right?
I need to correct something. CSM used to allocate matters directly from the assessment committee after they made a determination. However, in November 2020, that changed. We have a central allocations committee. So we assess and then forward the matters to the central allocations committee. Yes, correct.
All right, but moving on. So of course, CSM then would be responsible for referring complaints to other bodies as well. And sometimes complaints may be referred or rejected or subject to early resolution, which is what you describe in paragraph 10 as the event where a closing letter, sometimes also called as a closing report, would be issued, right?
Correct.
And there, no formal report would be considered assigned by the PP, and the matter would then be closed from your side at the PPSA, correct?
Correct.
You explain in paragraph 11 of your affidavit that you have a certain arrangement that you have made with the Department of Home Affairs in relation to complaints that concern that department. Can you just briefly explain to the committee what that arrangement is?
Yes. In terms of the public protector mandate, the public protector must investigate, must report, and must take remedial action. However, we receive a number of complaints which we term early resolution matters. Complaints against the Department of Home Affairs, for instance, where a person is complaining about an ID, birth certificate, passports, or visas. So those are early resolution matters that we think that they can be resolved without investigation. So in this case, what we do, we compile a spreadsheet. We put all those matters on the spreadsheet and refer to Home Affairs. And we meet once a month where we sit with Home Affairs and make sure that we resolve those matters. And once we have referred the matters to Home Affairs, we close the matter. So this applies to other organizations that I've mentioned in my affidavit. Thank you.
And you do also say that you have similar arrangements with other organs of state, right?
Correct.
So you talk about, whilst still involved with the business of contextualizing your unit, you talk about an assessment committee, and this considers the output of the assessors. Briefly contextualize this committee. What does it do?
The assessment unit has 4 assessors and the assessment manager. What happens is if we receive new complaints, they are registered by intake unit. Thereafter, the intake unit will refer the matters to the assessment unit, where they are allocated individually to assessors. And the assessors will look at the matters, assess individually, and then convene an assessment committee meeting, which sits twice a week for head office. In provinces, they sit sometimes once a week. They look at the matters and then they classify whether it's going to be an early resolution, a GGI matter, or the matter has to be transferred to Home Affairs. And in that meeting, they also consider whether the matter is older than 2 years. If a matter is older than 2 years, they determine whether the Section 69 of the Public Protector Act is applicable. This means that whether we have jurisdiction, because in terms of Section 69, a public protector may refuse to investigate such matters. And they have to look at special circumstances. And from the assessment committee, if they find that there are special circumstances, the matter will then be referred for allocation to investigations. And the investigator also has that role to check whether the Section 69 provisions are applicable. So the meeting decides and then records in their assessment form that there are special circumstances. If there are no special circumstances, of course, the assessment unit will close the letter and write to the complainant. In some instances, you find that you first have to get these special circumstances by interrogating or calling the complainant to find out whether there are special circumstances, what made them to refer the matter after 2 years to the public protector. So does the investigator when they receive a file. Thank you.
So in paragraph 17, you say that although there is this process, this general process for allocating new cases to investigators, there are instances though where investigators are assigned or allocated new complaints for investigation by the PP herself directly, right?
Right, correct.
All right. The customer service is another branch or unit within CSM itself, correct?
Correct.
And what they do is that they deal with and receive and process customer complaints, such as complaints about the service that the complainant is receiving from the PPSA itself, right?
Correct.
And then you also mentioned the remedial action unit, which you say has been part of CSM since June 2020. It used to be located in the private office. What does this remedial action do briefly?
Remedial action, after a formal report has been issued by the public protector, that report is then forwarded by the investigator or the province to the remedial action unit. It consisted of 1 manager until recently in June. The remedial action unit, they will now monitor implementation of remedial action by following up with the relevant departments, which we term respondents. And if there are 5 remedial actions in 1 report, they keep on following, following up on whether there is an implementation plan and whether if the complainant was looking for an RTP house, when are they going to build, etc., until the matter is finalized, is fully implemented.
And in paragraph 20, you just set out there an excerpt from a Q1 report that was submitted to the Speaker of the National Assembly on 30 June 2022, correct?
Correct.
Which shows the progress made by the remedial action unit in respect of 89 PPSA reports as at that date, correct?
Correct.
Right. So the next topic that you address is outreach in the PPSA, and you do so, of course, because outreach is another unit within CSM, right?
Correct.
Can you, Miss Motsitsi, just tell the committee briefly, please, about what is outreach in the PPSA and what its objectives are?
One of the critical functions of Public Protector South Africa is to ensure that a public protector is accessible, the services are accessible. And we have employed several mechanisms to make sure that we are accessible. We have outreach officers that will conduct outreach clinics in provinces. Each province has 2 outreach officers except the Northern Cape. They will meet with the members of the community. They will educate them, raise awareness about our services, and take complaints and bring them to the office. And over and above that, the outreach we also conducted through radio interviews where we allocate funds, budgets to provinces to conduct radio interviews. We normally use community-based community radio stations because in most cases you find that our complainants cannot afford to phone or to get to read about a public protector on internet. So through community radio stations, we educate them. And we also, what we do now, we have adopted the simulcast transmissions where we in the public protector, the executive authority will sit, and then we choose a topic to address. Like in the month of August, we're talking about issues affecting women because it was Women's Month. And now in September, we'll be talking about issues Heritage Month. And we have plans to go to Northern Cape to meet with the Khoisan community because of the challenges that they are experiencing. So, and we started with webinars, but we found that with webinars, we talk amongst ourselves as institutions. So it didn't have that much effect. But if you take all the mechanisms that we do to reach out to people to be accessible, you take outreach clinics, you take radio slots, you take simulcast, we find that it has an impact in a sense that we reach the far-flung areas and the poorest of the poor. Mm-hmm.
You've mentioned outreach clinics as being one of the tools in which you achieve outreach, correct?
Correct.
And in paragraph 24, you mentioned that there's specific targets that are linked to how many outreach clinics are supposed to be conducted.
Correct.
And you do say that the target was exceeded in the 2017-18 financial year.
Yes.
But that the approach did not define clearly where clinics should be held to ensure that accessibility was maximized, right?
True.
And then in paragraph 25, you say you looked in your capacity as executive manager, CSM, you then looked at the monthly and quarterly reports from provinces, and your analysis, you formed the view that the one-size-fits-all approach was not ideal for the purposes of maximizing funds because it didn't take into account or recognize the different needs of the different provinces, correct?
Correct.
So you speak of a new strategy then in paragraph 26 of your affidavit that was developed in November 2017 for outreach, and it was intended to be implemented over a period of 3 to 5 years. Tell the committee, please, about this new strategy briefly and what it entailed.
Yes, before 2018-19 financial year, the target was obviously the 756 clinics. However, you can conduct your outreach clinics outside your office. It was not clearly defined, it was not structured. So you can conduct, the target was that you must conduct 7 outreach clinics per month, 84 outreach clinics per province per annum. And yes, based on that, I looked at the reports, you'll find that the outreach officers only met with 2 people, 7 people here and there, but they have achieved their target of 7 outreach clinics per month. Now, taking into account that South Africa has 9 provinces, I looked at the fact that it's 9 provinces and they are divided into metros, and they also have district municipalities, and you also have local municipalities, and you also have municipal wards. And that target group in terms of our pillar, the pillars, Vision 2023 pillars, we wanted to reach out to far-flung areas, to the poorest of the poor. We wanted to get to the marginalized people. And how do you get there? You must have a strategy or a structure that will get you there. So I looked at each province, Gauteng with 3 metros and 2 district municipalities. I looked at Mpumalanga, you have 3 district municipalities. You look at KZN with 1 metro and 10 district municipalities. I compared all the provinces, and you looked at the population. Even though Northern Cape has a population of about 1.2 million, but the vastness of the province made it impossible for outreach officers to reach out to far-flung areas. Initially, the strategy was you have 2 outreach officers per province, and you have 1 car per province. And that motor vehicle is used for outreach, for investigation, and for administration. And if you want to achieve a target of 7 clinics, obviously, if you're in KZN with 1 metro and then 11 district municipalities, you'll go to nearer areas or areas that are convenient to you just to achieve the 7 targets. So in my strategy, I decided, okay, let's start with the district municipalities. The target would be each province would visit a district municipality, each district municipality. So the target was set on Gauteng will visit 3 metros and 2 district municipalities. Limpopo, it's 5 district municipalities. They'll also visit the 5 district municipalities. But because of limited resources, 2 outreach officers, the target was set at the number of district municipalities that we have per province, and obviously provinces encountered challenges. So
let's get to this issue of limited resources, because now you've alluded to it, and you do mention it in paragraph 27 of your affidavit. You say that due to lack of financial and human resources, this new strategy was implemented conservatively, right?
Correct.
When you came up with the new strategy in November 2017, were you aware of the financial constraints that you mentioned in paragraph 27?
No, I was not.
No, you were not, you say. When did you become aware of them?
In 2017, December, the then CEO, Mr. Chamberlain, resigned, and I was asked by the Public Protector to act. Obviously, as the acting CEO, you start first by planning to look at your strategy, your annual plan, and then you also look at the resources, the budget that you have. And then in December, obviously, we have 4 months left for the financial year. You look at the resources, whether we'll be able to cater for the next 4 months. You do projections.
So you're saying you became aware of the financial constraints when you assumed the position of acting CEO, is that right?
That's right.
Right. So you elaborate on these financial constraints in your affidavit, and you do so with reference to a memorandum that was prepared by the then acting Chief Financial Officer on the dated the 7th of February 2018, right?
Right.
And that's an annexure marked NM1. Please go there, Tsepo. It's on page 4228. Chair, I'm wondering if this is not a convenient time to stop because we're going to dwell quite a bit on this annexure in the evidence.
If you decide to give us 5 extra minutes.
We can start five minutes
Ah,
before.
no. Our time stays. We're back at 2 and don't hope to get back the 5 minutes. Thank you. We take a lunch break. We'll back at 2. Thank you.
Thank you.
Recording stopped.
No, it didn't.